Learned Instructing Counsel refers to the order dated 7/3/2026 and 6 similar interim direction regarding adjournment of the matter before the
certificate
officer. What is it?
We commission check.
Stop para. Accordingly, is directed upon such prayer being made before the certificate officer. The matter shall be adjourned beyond 11/5/2026 to a date as would be convenient to the officer in season of the matter. Yes.
My lord,
Item 5, my lord. On behalf of Manoranjan Acharya, my lord, his wife was hospital. Mona is Surendra Kumar Das, my lord. My pyro is not there, but his wife was hospital.
Das on behalf of Manoranjan Acharya. Here the opposite party is also wife of somebody.
Yes, my lord.
The matter was argued on 13/2/2026 and was adjourned by the Lord Counsel for the petitioner. Again, it was adjourned on 17/3/2026 by the Lord Counsel for the petitioner. Today, the matter being in the list is mentioned at the beginning of the day's proceeding, seeking adjournment on the ground of personal difficulty of the
His wife was hospitalized, my lord.
On the ground of personal difficulty of the arguing counsel. If illness of the wife is not his personal difficulty, you file a memo. But don't interrupt the dictation. Either be attentive, or if you are not attentive, leave it to the court. Personal difficulty कौन सेटा? अरे कौन muted है गले पूरा? कौन लेके? Or if you are regarding wife's illness ना कौन? Yes.
My lord,
the
item
man is laughing. Yes, at times that way it happens. कौन लेके? Arguing counsel to grant further opportunity to the petitioner. The matter shall be listed for fresh admission. In the week commencing 11/5. Full order भी से लिखियो to grant further opportunity to the petitioner. So like what sentence? Yes, ma'am.
my lord, item number 6, seeking for an adjournment, ma'am.
आपका नाम सर?
S.K. Patel.
So S.K. Patel for the petitioner. The matter was heard extensively on 17/3/2026. The facts and the legal issues were noted. The petitioner had adjournment for addressing the court on the issues noted. Thereafter, the matter was again adjourned on 8/3/2026 by the Learned Counsel for the petitioner. Today, Today, the matter being in the list is mentioned by the Learned Counsel for the petitioner seeking adjournment. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 11/5/2026.
Page 2, 10 to 16.
My lord, item 15. I'm praying for an adjournment, my lord.
आपका नाम सर?
Soumyaranjan Sethi.
Mr. S.R. Sethi for the petitioner. Item 15. The matter was heard extensively on 24/2/2026. The facts and the legal issues were noted. Adjournment was granted, adjournment was granted to the Learned Counsel for the petitioner to address regarding the issues noted. Stop. Thereafter, on 24/3/2026, the matter was mentioned and adjourned. Stop. Today, the matter being in the list is mentioned at the beginning of the day's proceeding. Taking adjournment, accordingly, the matter shall be listed for fresh admission.
We commission 11
11/5/2026 to grant further opportunity to the petitioner.
Okay.
Yes, next.
Item 17.
Up to 16 के नाम है ना 7 ରୁ 16.
page 5, 17 to 21.
Item 17.
Yes,
We have already entered appearance for opposite parties in law.
yes, your name is there, sir.
Yes. I require 3 weeks time
See,
to
on the
file.
side to go to, sir. In absence of the petitioner, don't mention. That creates lot of, confusion and they unnecessarily wait.
I will inform Mr.
So
General.
before you inform the court, you inform and then come back.
Item 7.
Because it's for orders CM appeal. CM appeal टा restore हेले आपनकर कुछ तो objection अछि.
नहीं ता जरे limitation टा अछि तो.
Limitation condone of course हबो.
ता
तो
जरे
सेटा ताको टी chance दियो. Don't,
अछि 2 वर्ष 2.5 वर्ष limitation.
Otherwise, can be condoned. Chipre किछि नाही, but ताको टी chance दियो तो आपण.
Good.
You give them a chance to argue their matter.
नहीं मु कहया कथा हो जे 2.5 वर्ष
ମୁଁ
corporate
କଣ ଖରାପ କଥା କହିଲି? In absence of petitioner, don't take a adjournment. ତାଙ୍କ petition. ଏଟା କଣ ଖରାପ କଥା? ମୁଁ ବି କିଛି ଖରାପ କଥା କହୁନି. ଆପଣ କହିଲେ ମୁଁ ବି କହିଲି. I think ମୁଁ ଯାହା କହୁଛି ଟିକେ ଭଲ ଆପଣଙ୍କଠୁ.
corporate client ତ ତେଣୁ କରି ଗୋଟେ ଛୋଟିଆ ପିଟିସନ ଗୋଟେ objection
ଆପଣ ସାର୍ କୋଉଠୁ ମନା କଲେ ଆପଣଙ୍କୁ? ଆପଣ କଥା କଣ ପଡିଛି ଆପଣ କହୁଛନ୍ତି କଣ? ମୁଁ କହିଲି ଆପଣ ଶଶିଭୂଷଣ ଜେନାଙ୍କୁ ଇନଫର୍ମ କରନ୍ତୁ. ଆପଣ କହିଲେ I will inform. ତ ସେଇଟା ଟିକେ ତାଙ୍କୁ ଚାନ୍ସ ଦିଅନ୍ତୁ. ଆପଣ ଯେମିତି yes,
Sir,
17
item 19.
adjournment noted.
Item 19. I am for the
Huh.
petitioner. Seek for adjournment to implement a party.
19 day Mr. Complied with.
Lordship. Already show cause filed. Sir, implemented party of me.
କଣଟା? ଓଡ଼ିଆରେ କୁହନ୍ତୁ ବା ଇଂଲିଶରେ କୁହନ୍ତୁ.
IGIT Saranga coming under SG and T department. जोटा कि हमें इंडस्ट्रियल डिपार्टमेंट इनिशियली पार्टी थिले.
ସେ ତ ଅର୍ଡରଟା ଲେଖିବାକୁ ପଡିବ ନା ଆପଣ କେବେ ଆଡଜର୍ନମେଣ୍ଟ ମାଗିବେ କି? ଯୋଉ ମ୍ୟାଟରରେ ଆଡଜର୍ନମେଣ୍ଟ ଦରକାର ନାହିଁ କାହିଁ ଆଡଜର୍ନ କରୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି.
2 weeks time.
ଅର୍ଡର୍ସ ମ୍ୟାଟରରେ 2 weeks ହଉ କି 4 weeks ହଉ ଆଉଟ ଅଫ ଟର୍ନ ତ ମୁଁ ନଉନି. ଆପଣ ଯଦି ବ୍ୟସ୍ତ ଅଛନ୍ତି କାହାକୁ କହିବେ ଇମ୍ପ୍ଲିକେସନ ଅଫ ପାର୍ଟି ଗୋଟେ ଛୋଟିଆ ଅର୍ଡରଟେ କରିବାକୁ ପଡିବ. ଆପଣ ସେଟା ଆଡଜର୍ନ କରିଦେବେ. ଏଗ୍ରି ସେଟା ଲିଷ୍ଟ ହବାକୁ ପଡିବ ନା ନାହିଁ? ଆପଣଙ୍କ ନାଁ କଣ?
पंकज कुमार साहू.
ଏ ଟ୍ରେନିଂ ଟା କିଏ ଆପଣଙ୍କୁ ସିନିୟର ଦେଲେ କି? ଭଲ ଭଲ ଟ୍ରେନିଂ ନିଅନ୍ତୁ. फाइलटा ଟିକେ ପଢିବେ ଦେଖିବେ spend your time, don't just spend your time in the ସିଧା କୋର୍ଟକୁ ଆସି ଯାହା ଟୁଲୁକୁ ଆସିଲା କହିବେ କଣ ପାଇଁ ଆସିଛି ରାଗ ଦେଖିବେ. So make some substance. ଗୋଟେ ଆରମ୍ଭ କରନ୍ତୁ. Someday you have to start some substantial submission ନା ନାହିଁ? Yes, 20 ରୁ 21 22 ରୁ 26
Item 26, man. And for the petitioner,
Mr. Roy, you are for no you are yes you are
26. Yeah, for the petitioner, madam.
yes.
I've received the copy of the counter affidavit filed by the university
डेट कर दो बिफोर वेकेशन चाहूचंदी
after vacation.
आफ्टर वेकेशन डेट कर दो
Sure, sir.
एक्चुअली धीरे धीरे बहुत मैटर हे गलानी एका
Yes, ma'am.
आफ्टर आई डोंट थिंक इट विल बी पॉसिबल नाउ.
Interim order to continue.
इंटरिम ऑर्डर कोन एडजर्नमेंट थिला ना स्टे थिला?
Status quo thila.
दैट इज इट्स नॉट बीन टच्ड.
Obvious.
आगे
We commission 6 sir.
Obvious.
Page 7,
Item 33 में 33
बेसिक गोटे सेट पेज रे
27 to 35.
आगे
22, your lordship.
22
22, my lord, I am for the opposite party, my lord, in this case. Just now I have received the copy, my lord.
22 टा डेट करबे
Date, my
डेट कर दो आफ्टर वेकेशन. देखो
Obligation.
4-5 now has crossed 92. 11-5 is 90.
Yes.
That is the situation.
11-5.
Obligation.
11-5 है.
Obligation.
ये space 7,
Space
27 to 35.
Item
33 million. Isn't it? I'm the opposite party. I have already taken consent of the from the petitioner. I will ask.
33 ଗୋଟେ date କରନ୍ତୁ.
We come in 6-7.
इतने maintenance दो ना.
My lord. No, maintenance. No, এটা against the local adalat order has come.
6-7 That's simply posted in the computer. Yes. Yes.
Item 31,
31.
this sub item,
Yes.
WPC 36310 of 2020.
Yeah.
That brief has been transferred from the office. My name may kindly be deleted.
Consent you have given any idea କେବେ ଦେଲେ? ମନେ ଅଛି?
It's a date on
ସବୁବେଳେ ନା. ଠିକ ଅଛି.
the entire case record is in
Because I will break bench then.
entire case record policy to
After division then. That's
only my name may kindly be deleted.
correct. I noted. That
Oh,
order
bless.
has to be passed. It has to be by judicial order.
Obligation.
Any more matter? 37 ରୁ 35
Item 34, you
34.
praying for an adjournment on behalf of Mr. P.K. Chand.
So Mahanti, Sitsangar Mahanti, your matter 34. The Chand is praying for adjournment. Date करियो तो.
We come in 6-7.
ये माने before vacation.
Before vacation.
Before vacation now the posting shows 180 in 2 days, 2 weeks.
Right.
Just କହିବେ ରଖିଦେବା କଣ ଅଛି? ତ ରଖନ୍ତୁ before vacation.
18-5.
Obliged.
Page 36 to 42.
Item 37, my lord. Praying for adjournment.
37 transfer. TRPC को mediation ଟା failed ନା କଣ?
My lord, compromise ଚାଲିଛି.
Mediation ଚାଲି अच्छा ଏଟା ଯୋଉ ଏଟା କଣ interim mediation? ଆଗ report ଟା କଣ report କଣ ଥିଲା?
13 ବି ଆମେ file କରୁଛୁ.
अच्छा ठीक ଅଛି और other side inform କରନ୍ତୁ because they
I have
expect
informed.
विचार on 30
Already
not there. That 37 ଟା date କରିବେ.
We come in 6-7.
Obliged.
Yeah.
Item 1.
Let's have filed the affidavit as directed.
This plea was before the Lord trial court.
For the trial court, no. This is after the judgment, my lords.
Then it is difficult, Mr. Ponda. Applying the tests that in division application, I cannot reappraisal of evidence.
No. I'm not
Your
asking.
difficulty regarding non-payment should have been considered by the trial court.
At that time, my lords, there was no question of payment. It had not been decided.
What is the direction?
Direction is after the closure of the case, it has been directed that I should pay 4,000 rupees per month as
So
maintenance.
for that, this is not entertainable.
Against that, I have come up.
Correct. I am rejecting this affidavit. If you are insisting, I am rejecting this. Because now the question is, you are very fair. To that extent, you are saying that this was never filed before the trial court.
It could not have been because. there
So what was
no
the evidence? So, I cannot now expand in revision.
No, I am not. Your lordship wanted me to file an affidavit
No, I have never wanted.
as to how I am going to.
No, I have never wanted. I say that if you want to challenge, then you secure it. That I want.
So I am saying that I have got this
So,
income which.
so what is the total area? Straight away come to the point. What is the total area and what is the amount due now?
Total arrears now as on date is 2,88,000.
So, and current,
As on date, my lords.
as on date,
Yes.
entire. So out of 2,88,000, how much you will pay?
Your lordship may fix some money out of this. This is my income.
1,50,000.
Your lordship may say so.
Okay.
but I need time to pay that.
No, you obtain it. The problem is that once you say the trial client, what I have seen, I mean, most senior lawyers with experience also, the trial client is not responding. So later, then I will issue notice.
It is not that, the client is not in a position to file an affidavit.
So that I will take care of.
The law-
In a division bench
law is-
matter,
Lords, the law is that only an able-bodied person can pay maintenance.
the law is also, Mr. Panda.
It does
the
not say that
able-bodied
somebody
person-
who is...
Correct, absolutely correct.
Yes.
You are thought on the point.
Yes.
But that is to be argued before the trial court.
The law also, my lords, is that only a wife can claim maintenance or somebody who in the eyes of society
No.
is seen as
So
wife.
there I beg to differ. I have read it, so I'll
Then your lordship may dismiss the revision.
yes, it has to be. It has to be. If he's not depositing the money, it has to be dismissed.
A criminal revision, my lords, cannot be dismissed merely because money has not been deposited. Because it is open to the
So I
lady.
give my reasons.
It is open to the lady. It is open to
will-
the lady to file a petition for execution.
I will give my reasons.
My submission before your lordship is
I'll definitely know that she's not your wife and incapability of
no.
not
That,
able-bodied
that
person.
is not enough, my lords. Your lordship may now look at the judgment then.
Yes.
If your lordship is not going to issue notice, kindly look at the judgment.
No, I am definitely going to issue notice subject to deposit of 1,50,000.
Then your lordship may say that.
I am saying that.
Yes, but your lordship will give me some time to make the deposit.
I have no difficulty, but then you have not heard me. When you said give me some time, I said that you file the affidavit. Let him come to court and say that I'll take this much of time and then deposit 1,50,000.
For
So
that again another affidavit.
Yes, you have not stated that.
No, your lordship may say that I'll comply with it.
No. You have to come up with that plea that I'll take so much of time. I have no difficulty. Because then it becomes a fishing expedition.
Why should it?
It has to be.
If
Because I do not know.
If your
when it will
lordship
take
will
compliance.
grant me 2 weeks or 3 weeks or 2 months,
Sir,
I will
Sir,
comply.
that is not a difficulty, sir. Did you tell that the petitioner says 2 weeks? No. You said that lordship grant me time. I said that let the petitioner undertake that he will file, he will deposit in so much of
Lords,
time.
all these nuances, my lords, I am not used to. That's why.
I am also not used.
That is why I'm
With very less experience compared to you, I am not also used.
No. So now I have to file another affidavit about this period required.
That is your choice.
Then your lordship has to grant me again another time.
Yes.
Adjourn.
By Monday.
No, it will not possible. I'll need time for till Wednesday.
In a division bench matter, we directed for medical examination. And one thing would happen that he was treated, whatever problem he had examined. So
Somebody who is paralyzed cannot be treated.
he should paralysis during the the petition and paralysis post petition are different.
No, here
No inability, Mr. Panda. I am talking about inability to pay. I'm not filing affidavit. Not filing affidavit. I'm not saying that.
now I'll ask your lordship to kindly look at the affidavit which I've. Please look at annexure B and C.
VRS has been dealt with by the Honorable Justice Deepak.
Hello?
Samima Faruqi is exactly the same case.
Your lordship may just look
Yes.
at annexure A, my lords.
No, just allow me to kindly listen, give me some time because it takes some time to dictate the order. I have to note the submissions because I am granting you that time to file affidavit.
No, because of the fact that your lordship said that post-order illness and pre-order illness.
VRS. Voluntary
Yes.
retirement during the sanction pendency has been dealt with.
VRS was applied for on 19/8/2019. That
Yes.
is before the petition was filed.
Yes.
Before the petition under 125 was filed.
Yes. So let him not pay his choice. What is the difficulty? Court will not aid and assist him, not mean not pay. Yes. The hard-learned counsel for the petitioner, Mr. Devasis Panda, for the petitioner. In response to the order, the matter was the learned counsel for the petitioner appearance clear. Opposite party black. The learned counsel for the petitioner was had at some length. The facts and the issues, the legal issues were noted by order dated 11/2/2026. Said order, it is submitted that the son of the petitioner has filed affidavit which states thus. Para 4 पे quote कर दे. It is submitted that the petitioners in seeking revision of the judgment dated 17/6/2025 passed by the Learned Judge Family Court Bhubaneswar in criminal proceeding number 304 of 2019. It is submitted by the Learned Counsel for the petitioner that the petitioner is not able-bodied to pay the amount directed.
May I be excused?
Yes, please.
The question your lordship put was whether I am going to secure it. And I have
No, sir,
said that by Wednesday I'll file the affidavit.
Sir,
Your lordship may give me that.
Sir, I will definitely give you time, but I'll record the submissions also.
So these
Sir, it's
submissions
not-
are not necessarily to be recorded. Not
Sir,
necessarily.
that will be.
If I am taking an adjournment only for that
No,
purpose.
after we have made the submission, I cannot withdraw it. Only. Able-bodied to pay the amount as he is suffering from paralysis. It is further submitted that the monthly maintenance can be claimed by somebody who is the wife or is seen to be a wife by the society. Regarding the present income of the petitioner, paragraph B, paragraph 4 into bracket small b, as reproduced above, indicates that he is receiving a pension amounting to rupees 16,500. Copy of the affidavit shall be served on the Central Government Council under DSGI. In the office of the DSGI, to enable him to obtain instruction
Yes, Chief.
from the commandant.
Lord, I am sorry. It
Odisha
is
State Armed
OSAP.
Police.
It is OSAP. I made a wrong submission that it is CRP. Book in the Orissa State Armed.
Then say quotation that ठीक अछि. ले तापर कोन लिखे? Commandant Odisha State Armed Police 7th Battalion Bhubaneswar, indicating the details of the total retired dues received, retired benefits and dues being received by the petitioner, the amount of pension received, the voluntary deductions paid by the petitioner towards any account from such pensionary amount. Further, during the deliberations today, the Learned Counsel is apprised of the fact that the facts stated in the affidavit dated 16/4/2026 filed by the son of the petitioner, whether was brought to the notice, whether was part of the pleadings and evidence before the Learned Judge Family Court in CRP 304 of 2019. Chapara. Regarding securing the regarding the amount due till today towards monthly maintenance. The direction is rupees 4,000 from the
The date of filing of the petition.
from the date of application. That is 28/11/2019.
With the areas being payable within.
The total amount comes to 76 ମାସ ହେଲେ ହଉଛି 3,00,000
3,04,000.
3,04,000 2,00,000 ଟଙ୍କା ଦେବେ କଣ 1,88,000 କହୁଥିଲି ଯୋଉଟା କଣ
2,88,000 ଆଜ୍ଞା ହିସାବ କରିଥିଲି ଏକ୍ଜିକ୍ୟୁସନ ରେ କ୍ଲେମ୍ ହେଇଛି
2,88,000 ଆପଣ 2,00,000 ଟଙ୍କା ଏକ୍ଜିକ୍ୟୁସନ ରେ ଡିପୋଜିଟ୍ କରୁନାହାନ୍ତି amount comes to 3,04,000 ନା ଏମିତି ହିସାବ କରି ଜାଣିଛନ୍ତି ତ from 28/11/2019 till 28 ମାର୍ଚ୍ଚ ଏପ୍ରିଲ 28/3/2026 76 months 4,000 into 74 equal to 3,04,000 is due. The petitioner has adjournment to give affidavit before this court, to file affidavit before this court that he shall deposit rupees 2 lakhs by what time in the executing court towards satisfaction of the amount due which is sought to be executed. As paid for time the affidavit be filed.
First, let that report come from the OSFP also.
ସେଇଟା ଫ୍ୟୁଚରରେ ହେଲ୍ପ କରିବ ଏଇଟା ଏବେ ଦରକାର ନାହିଁ
Future.
ଫ୍ୟୁଚରରେ ହେଲ୍ପ କରିବ affidavit be filed by 20 ନୁହଁ ଆପଣ କହୁଛନ୍ତି ବୁଧବାର 22 by
By 27 କରିଦିଅ
by 24 ଆଉ
27
ଠିକ ଅଛି by 27 the matter shall be listed in the week commencing 4/5 4/5 सर 27 के 30 कर दो 30 यदि एफिडेविट आगुआ फाइल कले लिबर्टी टू मेंशन कैन मेंशन लिबर्टी टू मेंशन एग्जीक्यूशन डेट केबे अछि डेट जानि छथि यंग मैन बुझी दियो जस्ट बुझी कोन सेति खाली हेले जदि सेटा दरकार पड़ियो ताकू अर्जन करया के पड़ियो पचाटा बुझी दियो इट इज ହେଲା ସେ ଖାଲି ଗୋଟେ ଲାଇନ ଆଡ ହବ ଗୋଟେ affidavit ଉପରେ ଲେଖିଲେନି affidavit dated 16/4/2026 was received in the court from the registry same shall be taken on record scanned copy be updated.
Item 2,
Item 2, my lord. Your from consent. Date has been fixed for execution, my lord. Date has been fixed to this 30th April.
ଆପଣ
I will pay, my lord.
you are for the appellate
18th, the execution date.
18 କେତେ?
18 tomorrow.
It is submitted by the learned counsel for the petitioner upon instruction that the execution is fixed to 18 4 18 4 20 26. In view of the statement made on behalf of the petitioner before this court, in the interim it is directed that the execution case shall be posted beyond a date beyond 11 ଆପଣ ଏଟା କେତେ ତାରିଖ କଲେ ଏଟା ଡେଟ୍ ଫିକ୍ସ କରି ଦିଅ ଏମିତି ଏପଟ ସେପଟ ହଉଛି ଗୋଟେ ଚାରି ପାଞ୍ଚ ହବ ତ listed on 4 5 that shall be posted to a date beyond 7 5 20 26 as would be convenient to the learned court in season of the matter. जो अमाउंट कैलकुलेशन लिखिले गोटे लाइन तो पूर्व लिखे upon instruction received it is submitted by the learned counsel for the petitioner that petitioner remains in default of the entire amount due. That is the instruction that they नानी कहउछन्ती 18 5 से कहउछन्ती so it will be urgent 4 5 it will be urgent beyond केते कहसे 7 5 अपने प्राइवेट में
4
Again?
18
चार 18
I'm sorry, 18 4. 18 4 को डाकी actually month shift हो गला 5.
This order of today's may be uploaded in the court switch.
Yes, yes. I'm trying that. I'm instructed, but today there is some assignment after the lengthy assignment. Parties to act upon the copy of the order obtained from the official website of this court. Yes.
Item 2, my lord, I had appeared through consent, but
Petitioner का पाई.
petitioner point. But the Bakalatnama has not common record.
What SS महापात्र जो सित्रे नांती महापात्र जी से आवजने महापात्र. अच्छा दी तो.
अच्छी पावर टा देखौची सूर्य महापात्र. But
अपन physical कपड़े देखिए पूरे.
no.
Yes, go. Now we'll go to that. I'll pass orders. Court hela kul.
My lord, the executing court has fixed date on 30th. Now, my lord, I had asked my client to pay because without payment, my lord, he has no rights of audience reposition. Lordship may adjourn.
I mean, being a young counsel, I know I have marked you, but you are too fair.
My lord,
But this will help you. Because ordinary person coming to you, if he gets good legal advice, that will be respected. That is my humble experience. Whoever, however so high, or whoever is, some menial job he is doing, at times somebody will come and say that I'm peon and so and so office. I have come to meet you, sir has said things. So even he will have respect.
my father has always
No, I know.
that you attend the poor clients first because rich ones have already good lawyers.
Not necessarily, not that way. But these what I find this branch of this maintenance is completely clouded now.
Matter.
I mean the entire law has been distorted. ଗୋଟେ ବର୍ତ୍ତମାନ ଗୋଟେ ଡେଭଲପ ହେଇଛି ଯେ ଦବାର ନାହିଁ ଦବାର ନାହିଁ ପ୍ରୋଭିଜନ ନାହିଁ ସେଟା ପାର୍ଲାମେଣ୍ଟାରୀ ଆମେଣ୍ଡମେଣ୍ଟ ଦରକାର.
My lord, my submission is that with no pay, no audience. So I had asked him to pay at least 1/4, 55% let him pay.
No, 50%. Because the problem is that even if you take the human rights and suffering, individual, that there is another soul who is dependent on this. The court has adjudicated and determined. It is not all. It's not a ex gratia. Suppose somebody is suffering, state gives ex gratia. I will make an application. But this the court has determined. This is the amount that should be paid to the person and the child maybe. Here child is there,
No.
but child is not there.
Not there. Sinna wakalat na matter. My lord, may adjourn this matter to second week of May, my lord. Let him pay.
Okay.
My lord,
And leaving it to the lawyer is becomes difficult because they never comply unless the court insists.
Hmm.
One of our seniors, he directs for arrest and detention. To that extent, I have not gone, but it had an impact. I have seen sitting in division bench, he directed arrest and detention. So then
my lord, in maintenance.
suddenly everyone becomes able-bodied. In another division bench, somebody suffered from paralysis. When he was directed to be examined by the CDMO, he rode a scooter. That is the report.
My lord, trial.
He regularly appeared before this court also.
Trial court in one of the matters, my lord, that husband came up with a bag and said, "Mu 14 jail jibi pehle paisa de deni."
That has happened in Jaspur.
And
For
cut off-
80,000 rupees, 1 month imprisonment. But that is not the end of the it. But because distress warrant, the property list should be there with the wife.
My lord.
Property list still in Jaspur case, what happened? The wife could not furnish the property list. So obviously the execution after 125(3), after she was arrested and detained, nothing could happen because he becomes guest of Mr. Lenka. He gets free food and well attended, medical health, everything is there. See, whoever, however, has a determination to defy law and go to jail should be tackled by law only. And by lawyers like you. Right? ଆପଣ ଅନଲାଇନ ଫାଇଲ କରିଥିଲେ ନା ଫିଜିକାଲ ଫାଇଲ କରିଥିଲେ?
Physical file.
ଆପଣଙ୍କର ଫିଜିକାଲ ଫାଇଲଟା କୋଉଠି ରହିବ? ଅଛି ନାଇଁ, ଆପଣ ଯୋଉ ଫାଇଲଟା ଧରିଛନ୍ତି ଏଇଟା ଅନଲାଇନ କପି ନା ଫିଜିକାଲ କପି? ଫିଜିକାଲ କପି। ଫିଜିକାଲ କପିରେ ଅନଲାଇନ ଓକିଲତନାମା କପି ଅଛି। So I have understood. Okay. Mr. Surya SS Mahapatra na Surya Sundar.
Surya Snatha Mahapatra.
Surya Snatha. Mr. Surya Snatha Mahapatra for the petitioner, opposite party blank. Is submitted by the Mr. Mahapatra that though his name is reflected in the cause list, the physical copy of Wakalatnama is not tagged. Gomakis Tripathi appear Korunan. Consent teacher. It is submitted that Wakalatnama has been filed physically. Upon obtaining consent from the learned counsel for the petitioner who was appearing earlier. Upon kebe file karthile man purchi.
7-1.
The receipt of filing of Wakalatnama is retained by the learned counsel, which shows he filed Wakalatnama on 7-1-26. The court master, upon verification of the physical record, submits that in the physical records of the brief, the downloaded copy of Wakalatnama is available. Staff registry shall locate the physical copy of the Wakalatnama and tag the same. Stop. Para. Name of Mr. Gomakis Tripathi and Gomakis Tripathi, learned counsel and associates shall be deleted from the cause list as well as the case brief appearing for the petition. Who were appearing for the petitioner earlier? Mr. Mahapatra, I was just telling you just now that once the lawyer says that you have to deposit, they change counsel. Because you will find here, Mr. Tripathi argued on past date. 23-2.
And before that I had appeared.
But Gomakis Tripathi's name is there. So that's a mistake because of this.
My lord, he was appearing, but I had appeared through consent on 7-1.
Did he appear?
Then he appeared.
23 କିଏ appear କରିଥିଲେ? ଆପଣ ନା ସେ? ଅର୍ଡରଟା ଦେଖନ୍ତୁ।
He matter was listed on 23-2026.
Correct. But last order.
I had appeared on 7-1-2026.
He didn't have idea.
No.
Right. But most likely that is the case.
Well,
Unless you ask them to file affidavit, it will become a hide and seek game. Matter is adjourned again and again, and this court doesn't have the authority to, execute that way also. Okay. Upon review, it is submitted by the referring to the order dated AC 2 paragraph 3 is submitted by the learned counsel for the petitioner that he may be granted further time to obtain instruction. Regarding the petitioner securing the amount due, which comes to
1,20,000.
approximately 1,28,000.
Application was filed on 10/1/2025. This is 1,10,000.
Comes to around 1,10,000. The best level.
Second week of May.
Commencing 4/5 na 11/5.
18/5.
We commencing the matter shall be listed in the week commencing 18/5. I'll just take some break and come back.
Fine.
OSAP is you. What Mr. Ponda had submitted that he retired from CRPF.
CRPF is central government.
CRPF central government. Today he says that he has had
Odisha state.
OSAP 7th battalion. 6th battalion, 4th battalion I think is ONC. Or 6th battalion. 7th is Bhubaneswar. 6th is Cuttack, 7th is Bhubaneswar. So copy, you require a copy of the petition also.
Yeah.
Or the affidavit will do.
No, let him Highly copy.
So registry will provide. Yes, next please.
Item 4.
Last occasion also was absent picture also. She may see the order dated 24 to 26, paragraph 4 and 5.
Yeah. କଣ କରିବା ସେ ମଧ୍ୟ ଆସୁନାହାନ୍ତି
Another last opportunity. 2020.
petitioner none. Mr. T.N. Lenka for the AGA for the opposite party. None appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 23/3/2026. The Learned AG refers to the order dated 24/2/2026, paragraphs 4 and 5. And submits that in view of the aspect noted in the said paragraphs. Refers to the order dated paragraph 4 and 5, which are reproduced herein. They submitted that in view of the observations made as quoted above, the matter should not be adjourned further. The matter shall be listed. Shall be listed for fresh admission in the week commencing 11/5/2026. Indicating in the cause list that the matter shall be disposed of. Copy of the order along with copy of the order as well as the next date of listing shall be intimated to the Lord Counsel for the petitioner by the registry.
Item 7.
Many times, Mr. Lenka, actually, adjournment is granted only to. You are absolutely right. This matter should not have been adjourned because there is already an order by the High Court. But only since I adjourn, give little bit liberal, so that is how I granted adjournment. Hopefully that the Lord Counsel would have obtained instruction or taken, made up his mind, but that is not happening.
It's my duty to just.
Yes, absolutely. You're absolutely right.
Item 7.
May Mr. Lordship.
Rabindranath Devata for the petitioner. Opposite party blank. The Learned Counsel for the petitioner being present at the virtual court, High Court of Orissa, Hon'Ble addresses arguments. Yes, Mr. Devata.
My lord, as per the previous last state undertaking, I have deposited rupees 30,000 and filed an affidavit to that effect. The total amount deposited by me is 1,24,000.
Okay.
I filed an affidavit to that effect, my lord.
The affidavit is dated 6/4/2026.
Yes, ma'am.
Yes, in the left margin, Bhuvaneshwar Nanda. Yes. So this you have deposited in the executing court.
In the executing court, and yesterday the opposite party has collected the amount.
Okay.
Entire amount. My prayer is that, my lord, the revision may kindly be admitted.
Next date before the executing court, Mr.
29th of April. 29th of April, my lord.
29/4.
29/4.
Okay.
And I have prayed for stay of the execution proceeding, my lord.
No, I'll direct adjournment of the proceeding. Since you have already deposited and he has collected, your mother has collected. The petitioner's mother has collected.
Yes, my lord. And this revision is preferred against order dated 27 January
Correct.
1926, under which the maintenance amount was reduced
Order
from
dated 11/3, ଏଠି ଲେଖନ୍ତୁ, had noted counsel for the petitioner. He refers to the earlier orders dated 11/3/2026, 31/3/2026, and submits that the petitioner has filed affidavit dated 6/4/2026, indicating the total amount of rupees 1,24, 1,24,000 that has been deposited before the learned executing court. Upon instruction, it is submitted by the learned counsel for the petitioner that the opposite party has collected the amount. Opposite party number one
there is only one opposite party.
only one, yes. The respondent, the opposite party has collected the amount from the learned executing court on 16/4/2026.
Yes, my lord.
On 16/4/2026. ଏମିତି ଲେଖିପାରିବେ yesterday collected amount yesterday, 16/4/2026. Stop. Issue notice along with the order dated 11/3/2026 and today's order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within
7 days, my lord.
within 7 working days. A returnable date be fixed to 15/5/2026.
My lord, I crave leave, my lord. On 15th, I will be absent, my lord.
No, in 18th week, are you available?
No, my lord. From 10th to May to 20th May, I will be absent, my lord. 22nd May. Let it go after vacation or before 10th.
Returnable date be fixed to 15/5/2026. The matter shall be listed in the week commencing 6/7 କହୁଛନ୍ତି ଏବେ କେତେ ଡେଟ୍ କହୁଛନ୍ତି 6/7 week commencing 6/7/2026. IA 71/2026. Issue notice as above. Accept one set of process fee and postal requisites. Returnable, the next date of listing, the returnable date as well as the next date of listing would be as directed above. Stop. In the interim, it is directed that the pending execution proceeding number ta koi paribe
11 of 2025, sir. 11/25.
11
Yes, my lord.
11/2025.
Yes, sir.
11/2025 before the learned judge family court. Arising out of CRL criminal miscase number 31 of 2025
Yes.
shall be adjourned beyond upon 6/7 कहले shall be adjourned beyond 13/7 10/7 adjourned beyond 10/7/2026 to a date as would be convenient to the learned court in season of the matter. Urgent certified copy as per rules. Yes. You are getting the certified copies at Sambalpur, Mr. Devata?
Yes, my lord. We are getting e-certified copy.
Okay. Yes, next.
Item 8.
Obliged, my lord.
Yes, please.
May I please your lordship? I'm appearing for the petitioner.
Your name, sir?
Amartya Nandan Patnaik, sir.
Amartya Ranjan?
Amartya Nandan Patnaik.
Power nahi.
sir, अच्छी AN पटनायक लिखा होती है.
Acha, item 8. I'm
Yes.
sorry. Second part. So, Amartya Nandan Patnaik for the petitioner. Yes, what do you say, sir?
So the fact of the case is that the petitioner is the wife of opposite party. The opposite party has filed a petition under section 9 of Hindu Marriage Act for restitution of conjugal rights. My lord, the petitioner is currently residing at her parental house right now, which is about 200 kilometers away from the house from the family court judge Puri. And she is a destitute lady and having no fixed source of income, and there are no male members in her family except her father, who also has no fixed source of income. Therefore, I pray your lordship to kindly transfer.
What is the most crucial part in case of a section 9 application? Have you thought that before filing the application? Did you interact? Did you have the client interview? What is section 9 about of Hindu Marriage Act?
Restitution of conjugal rights.
Correct.
It means.
So the lady, did you ask the lady that whether she wants restitution or not?
Sir, she was tortured physically and mentally. That's why.
You must understand that we are being watched. Must understand that we are being watched. At times, recorded people are watching that. When the court asks you in High Court, the context of a section and application, that did you ask the lady that whether she wants restitution? The answer is to be binary. Today's answer is that she was tortured. Yesterday's answer was the mother-in-law interface. That cannot be the answer. The answer is binary.
Sir, she wants.
Yes or no?
No, sir.
She doesn't want. So you should say that. You should say that. Because then you can have further thought in your mind to argue the matter. I mean, I'm not finding any fault. Please don't. But your approach should be this profession. The beauty of profession is that you have to be very particular. You can't come with a blank mind and start blabbering something. You are doing exceedingly well. I am not pointing fingers at you. Please don't misunderstand that. But in case of a section 9 petition, if the wife wants restitution, then law is not for frustrating that. And also, did you read the provisions? Which provision you have to file the transfer application?
Yes, sir. 24 CPC.
24 CPC. Did you mark the language? Anyone can file.
Yes.
But the last part is that looking at the convenience of the parties, plural.
Yes.
And which is the provision conferring a jurisdiction on a child court, family court act? Which provision? Read that. Whenever you are filing an application for seeking transfer, you must find out which provision confers jurisdiction.
Yes.
CPC, which section confers jurisdiction? Is there. Section 9 is there.
Yes.
Family Court Act, section 19 is there. And if you read 9
Yes.
of CPC, 19 and 24, 19 of Family Court Act,
Yes, sir.
24 of Hindu Marriage Act, then what you are submitting, those are not valid grounds. For a destitute lady staying at 200 kilometers away, having a child, no support, can the court give a finding that suppose you are destitute, then you have to seek legal aid? Nowhere the court travels to the person's house. You cannot have a court, family court inside. It's not kind of a commission of inquiry. The child is never to be taken to the place where the court functions. You require somebody who will take care of the child. We are having crutches because now we are mandating crutches. Mandatorily, crutches have to be there in every court. Well-equipped crutches also there. So those are the aspects you have to think. And Obviously, you have done a good job in arguing the matter. But please keep these things in mind so that the discussion in the court becomes legally nuanced. Had learned counsel for the petitioner. The petitioner wife is before this court seeking transfer of the CP number 1042026 pending before the learned judge, Family Court, Jagat Singhpur. Stop. The said CP has been initiated by the husband in the marriage under section 9 of the
Family Court Puri.
Family Court Puri.
Yes, sir.
Family Court Puri. Jagat Singhpur Puri kar initiated by the husband in the marriage under section 13 of section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Counseling को provision को act रे counseling नहीं परियो. Family Court Act.
Yes.
Family Court Act रे counseling is mandatory.
Yes.
Family Court counselor got a provision ach. They are appointed in every family court. Do you have a family court counselor in High Court?
Yes.
There is no provision. Nahi. CPC रे की section 24 रे family court से counselor nahi.
Yes.
So in this process, the entire mechanism is getting frustrated or delayed, or that bottleneck is created. When the two individuals, two human beings are worrying that they are quarreling, then why this provision is made for counseling? Because law is concerned regarding reconciliation and restitution. Only the counseling nahi.
No, sir.
Money suit, property suit, declaratory relief. There is no counseling. Why this concept of counseling mandatory in Family Court Act? But by this court's interference, counseling cannot be done. And the language used by Supreme Court is that the feelings get frozen. ଆପଣ ଯେତେ ଜଲ୍ଦି କାଉନସିଲିଂ କରିପାରିବେ law or initiative. Because she lives in past. She was tortured. She must be telling truth. Let us start with that. But she wants, suppose that there is a possibility of, because marriage is a sacrament. In our concept of law, Hindu law,
Marriage is a
sacrament. So that is how it's an institution. That is all the efforts. But by interference in this manner, the entire scheme is getting, bottlenecks are created. Created by the husband in the marriage for restitution of conjugal rights. It is submitted by the learned counsel for the petitioner that after the marriage has gone into rough weather, the petitioner stays with her parents at Puri.
Jagat Singhpur.
At Jagat Singhpur. And she finds it difficult to attend the matter at Puri. Attend the matter at Puri. Stop. Issue notice along with this order. Requisites for issuance of notice by speed post with and proof of delivery shall be filed within how much time to file requisites? 5 working days.
By Monday.
Within 5 working days. Returnable date be fixed to 15/5/2026.
Sir, I have also filed an IA. Kindly, sorry.
15/5/2026. The matter shall be listed in the week commencing 18/5/2026. IA 107 of 2026. Had learned counsel for the petitioner. He reiterates his submissions as noted above. Stop. Issue notice as above. Accept one set of process fee as well as total requisites. The returnable date as well as the next date of listing shall be as directed above. Stop para. In the interim, it is directed that the CP number 105 of 2026 pending before the learned judge, Family Court, Puri,
Yes.
shall be adjourned to a date beyond 22/5/2026 as would be convenient to the learned court in season of the matter, upon a prayer being made for the said purpose. You have to appear and make a prayer. Yes, next.
Item 9.
Item 9, may I please, my lords?
Yes, please.
Lords, this is a transfer application filed by the wife only to avoid conflicting judgments, my lords, from family court to Bhubaneswar to family court 1 Bhubaneswar, or vice versa, whatever. My lords, the present
One matter is at 1, 2, 1.
and another matter is at 2. So that in order to avoid two conflicting judgments, my lords, this application has been filed. Either it has to be.
So, what are the two applications?
My lords, I have filed an application for divorce. Husband has filed an application for restitution of conjugal rights. My lords, this matter be resolved.
So, your divorce application is pending at which court?
My lords, family court 1.
1.
My lords.
9 at family court 2.
2.
So, Devidatta Mahapatra for the petitioner, item 9. The petitioner wife is before this court. Seeking the CP number 1136 of 2024, seeking a direction for CP number 1136 of 2024, pending before the learned judge, family court 2, and CP number 391 of 2025, pending before the learned judge, family court 1, to be taken up together by any of the courts, that is family court 1 or family court 2, Bhubaneswar at Khurda. Khurda at Bhubaneswar, no, Bhubaneswar at Khurda.
My lords, Khurda at Bhubaneswar.
Khurda, family court 1, Khurda at Bhubaneswar.
Khurda at
Bhubaneswar. Khurda at Bhubaneswar.
My lords, that is district judge of Khurda at Bhubaneswar. It is only family court 1 Bhubaneswar. Khurda.
Family court Bhubaneswar. 1 Bhubaneswar. 2 Bhubaneswar. The CP 391 of 2025 has been filed by the wife in the marriage. CP 391 of 2025 has been filed by the wife in the marriage under section 13 into bracket English 1 into bracket small I dash small a bracket closed of the 1955, seeking a decree of divorce, seeking dissolution of marriage and grant of decree of divorce. Stop. The CP number 1136 of 2024, pending before the learned judge, family court dash 2. It Khurda lekha hoche. Khurda. Page 31 lekha. Khurda at Bhubaneswar. And a family court is actually for the district.
My lords.
31 dekhile.
My lords.
Khurda at Bhubaneswar has been initiated by the husband in the marriage under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. 34 टा की फाइल करछथि जो पेज 34 आपण
Page 34. 34, my lords, they have filed.
तेरे सेक्शन लिखा होनी
Man लिखनांदे.
ठीक है कौन लिख ले issue notice along with this order indicating that the matter is likely to be disposed of at the stage of admission. Stop. Petition for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
3 working days, my lords.
Today, why not today?
My lords, I can.
5 is always the outer limit.
I'll do it, my lords.
So what is the difference between 3 and 5?
2 days, my lords.
That's not the difference. If you do not comply within 3 days, again the matter gets listed.
My lords.
The list gets plugged.
My lords. For orders, my lords.
That sort of that is an avoidable thing.
My lords.
within 3 working days, refuses for issuance of notice, within 3 working days, a returnable date be fixed to 15/5 2026 20 15 न କରି କରିଦିଅନ୍ତୁ 12/5 12/5 ଏଠି 17 ଟା 12/5 ଇନୱିକ୍ ପରେ ହେଇଯାଉଛି ନା ରିପୋଷ୍ଟ 12/5 distinct week commencing 18/5 2026 IA 116 of 2026 had noted counsel for the petitioner. He reiterates his submissions as noted above. Stop. Issue notice as above. Accept one set of process fee as well as postal requisites. Returnable date and the next date of listing shall be as directed above. In the interim, it is directed that CP number 391 of 2025.
No matter. The other one. 1136 or 2024.
Both have to be adjourned now. 391 of 2025. Pending before the learned judge, family court 1 Bhubaneswar. And CP number 1136 of 2024. Pending before family court -2 Khordha at Bhubaneswar. Shall be adjourned to a date beyond 22/5/2026. As should be convenient to the learned courts in season of the matter. Awaiting further orders from this court.
One more observation, my lords, may I pray, my lords?
Yes, please.
My lords, there is a possibility of settlement between the parties. So if
Stating that we're filing a TRPC.
no, my lords, if because they are not
to be.
cooperating.
See, I cannot direct conciliation. There is no provision.
My lords, not for conciliation.
Mediation will work.
Only mediation.
So whenever a notice is issued by the family court, the lawyer comes to High Court, files a TRPC or WPC.
My lords, with
Just now I was discussing with a young counsel.
my lords, so one observation that if they cooperate with the mediation on the next.
Indicate that they will not cooperate. You see, the courts are not for inviting people to comment on their conduct. Just understand.
Next date, let
A
them
lawyer
appear.
could do that also.
My lords.
Whatever impresses you from told by the client, don't say that in the court. Add some legal ones. Whether they are cooperating or not cooperating is not a subject matter.
Let them appear, my lords.
So no, let them whatever. But you are inviting interdiction of both the proceedings. So it has been done.
My lords.
So damage is already done. Then whether cooperate or not cooperate, the matter when the matter is adjourned, will the court proceed?
Let's that
The court cannot.
That was not.
Even for conciliation, the court cannot proceed.
My lords.
I don't know how it is. The entire scheme has got distorted. Section 9 reconciliation, how section 13 reconciliation and it is only one campus also. So both aswidhar achanti, chua achi, bapa mang pakhare rochhanti, those pleas are not available. So I don't know how the things are being now I think Supreme Court in one matter 80 cases. Live blood came of some 44 I have seen, 44 cases against each other.
My lords, that
So, Odisha is 37. In one matter, 37 I have seen.
multiple and
So obviously, lawyers are not complaining. But the entire, legislative intent of going for conciliation and
mediation.
Mediation to statutory conciliation achi, counseling. Counseling ta etre he Anyway,
Obliged, my lords.
enough has been said on this. Yes, next.
Item 10.
Item 2, may I please, Your Lordship. Item 10, my lord, I'm challenging the order dated 30.
It is asked for the petitioner. All Odisha Truck Maliko Mahasangha.
They have the order dated 30/12/2025 passed by opposite party number 2 to change the name of my association. That
Which
without
provision challenge kurchoti? Which provision?
Your Lordship, may for a moment page number 30. Your Lordship,
No, don't be specific. Leave
That
this
is
habit
12
of
12D.
leave this habit of referring to a page when the court is asking you a provision.
That is 12D.
12.
12D of Society Registration Act.
Point on. Repair academy. Profession is to certain extent very difficult, to certain extent actually easy, but you have to develop the good habits. Yesterday we were told, we were attending one, you were present in the conference yesterday, Bar Association organized. We had the fortune of hearing Justice Patnaik, the Advocate General, the Chief Justice. You should not actually. You should attend in these kind of things.
Yes.
Prior to that, Justice A.K. Patnaik arranged, he gave a lecture on, I think, some memorial lecture for council, how the juniors, how the seniors come into picture, how they help the young counsels. He narrated his experience. So it is worth listening.
I'm sorry.
No, why should you be, and leave this habit of telling always sorry. Let's say sorry is a very...
No, I'm unfortunate that I was not there.
Fortunate or unfortunate, no fault is found out so that you will tell sorry. Use of sorry has become really, actually, now it has to be curtailed by some legislation. Kete question 12?
12D.
Oh. The power to cancel registration.
That is cancel or any order. That is provided that that is 12D proviso that no order or cancellation which shall be passed without giving the concerned social.
One question आपण बुझले कौन? आपणकर सोसाइटी रो ना चेंज करा गला. डायरेक्शन को प्रोविजन ने से प्रोसीड करले सेटा पचरा होछ.
Na change we have applied to for a give our name our society to certain name minor, but without considering the letter passed by opposite ADM that they have passed order to change the name of my association without considering the letter. Though there is not a specific provision, there is no such specific.
Slow gontu, vote kono kochone pujontu so that I can understand.
Yes,
What is the sequence? You applied for giving a name. Namakarana pe apna application.
No, I applied under Annexure 1
for registration.
For registration of.
You gave your name.
So
when they granted registration, they did not allow you that name.
Thereafter, inquiry has been conducted under Annexure 3 by.
Again, you are missing the point.
No, on the basis of.
Did they allow you to give that name, or they did not allow you to give the name?
On the basis of my application, my lord, and officials of opposite party to inquiry directed video.
Was that the question? Let us be fast. After you applied for registration of a particular name,
yes,
was it allowed or not?
How could it be allowed without conducting an inquiry? Thereafter, opposite. How could it be, my lord? It cannot be allowed without conducting any inquiry. Whether my society is is handling properly or maintaining properly. Thereafter, a letter passed by opposite party officials to conduct an inquiry, my lord. An inquiry report is inquiry report is there under Annexure 3, my lord. Without conducting any inquiry, no, I cannot be my application cannot be allowed, my lord.
Which is the best language you understand, Odia or English?
I understand whatever lordship said. I understood.
No, lordship can speak some other languages also. So because I find it very difficult to understand what you are submitting, so that is how I think that I will change the language also.
The lordship.
No, I am extremely sorry that I have not been able to understand what you are saying.
My lord,
you have to record and adjourn the matter.
No, my lord, no. My lord, I have submitted an application.
Never ask a question to the court. How they will conduct how they will give a name, that is not discussed also, madam. Once you say that you moved an application before under 12D for naming or registration.
No, not under 12D.
Apna 12D padele.
12D ta mor samane name change kariya order karchandi mu seta any order.
Provision registration.
That is 3 and 4, my lord. That is a bylaws of company's bylaws are there under Annexure 1, my lord. That is.
Bylaws is not binding on the society.
No, I'm not saying that is.
Who provision invoke kale apanakara apply jetebale kale? Which provision you invoke when you applied for registration?
That is one a memorandum.
Apana thik achi habani. Apana impugned order ta dekhan.
Impugned order.
Sir, 6, page 31. In his presence, the order has been passed. Annex of page 31. The case is taken up today. Both parties are present and heard. An allegation petition was filed by Sri Rabinarayan Satpathy, General Secretary, Odisha State Truck Owners Federation.
Madam, are you happy when the DG reads, or you will read it yourself? Because you may not like him reading your.
No, it is not.
You can read, you can place. He is simply placing.
It's not.
So that is the problem.
I don't understand.
Yes. Upon nije padho, later read so that she can understand the.
Yes.
The case padile.
Yes, madam.
Which case? That who case? Who provision? Chachi. Any idea? Upon a pachar the client ku.
Idea that is. I have applied for registration of my.
Which case? Which case? There is application achi kichi tara.
Mu to Annexure 1 re achi mu deichi seta before opposite party to mu karichi seta application.
Apona Annexure 1 refer ethi discuss each mane decide hela boli kichi jana motte ki jana
Sei basis re sabu
apona semti inference karonto eta kono.
No, my lord, on the
apona gote adjudication re there is always an application or a dispute, so that is the question.
My lord, may I?
Do you have any idea? Do you have any idea regarding what is the case? You can say no difficulty. Apona nahi कहले
submit sequentially, my lord. My lord, submit sequentially.
पढ़ंतु अपन जोड़ा जानी नांती नहीं करले किछि असुविधा नहीं.
नहीं.
But let us not say discuss so many things at a time.
No, my lord. Your lordship.
ठीक है, kindly read.
That is the case record is my lord. The case record means the application I have submitted. Then thereafter objection on the basis of all the case record considering all the facts, my lord. I have submitted an application. There
order ta padhibe ki?
Again, that is allegation of petition was filed by Sri Rabinarayan Satpathy, General Secretary or Odisha State Truck Owners Federation, requesting the registration should not be allowed in the name of all Odisha Truck Malika Mahasangha. The objection related to the proposed name of the society, which is governed under Section 3 and 4 of the Society Registration Act. There are societies relating to formation.
Punctuation achi my lord कहले से sentence ta gala. Respect the punctuation in the sentence. Relating to formation and
registration of societies. Prohibition on identical or misleading name as per registration norms and administrative instruction issued by the IGR. Upon hearing both the parties and examining the submission, it was observed that the proposed name may cause confusion or similarity with existing registered bodies, attracting restriction under the above provision. The IGR cum register or societies, Odisha has been pleased to advise the Secretary of all Odisha Truck Malika Mahasangha to change the proposed name and resubmit the registration proposal in accordance with the Act and guidelines. In view of the above, the following order is passed. The Secretary of all Odisha Truck Malika Mahasangha is directed to modify the proposed name of the society and resubmit the registration proposal in accordance with the Act and guidelines. With this direction, the case stands disposed of. The parties concerned shall be intimated accordingly.
Yes. So now you got the provisions also, which I was asking you. Is Section 3 and 4 as well as the formation, registration of societies, prohibition on identical misleading names, registration norms and administrative instruction issued by the IGR. So these are the provisions. So now you are challenging this order.
Yes.
Under what are the grounds of challenge?
Well, grounds for your lord, for a moment, your lordship see page number 30, Annexure 5, which is the inquiry report submitted by ADM. Page number 30, my lord, Annexure 5.
So ADM's inquiry report is binding on the IGR.
Because ADM was directed by opposite party to conduct an inquiry.
Is it binding on the IGR?
Where he has been directed to conduct inquiry.
So you must have to show a provision that because you are saying that since ADM is directed to inquiry, the ADM's ADM's inquiry report is final. In the adjudication, that you have to substantiate.
May not be filed, but he must have considered the while passing the order dated 30, and that is what I am challenging. Your Lordship, for a moment, your Lordship, see page number 30.
And there, I don't have to turn
That is
pages.
second para. I'm starting from second para, my lord. Or should I read from the first, my lord?
Always try to read the entire thing so that you get comprehend what is there.
That is letter to the Inspector General IGR. That is, in inviting a kind reference to the subject called above, I am to submit that receipt of the registration proposal to online for due inquiry and recommendation by the application ID 1820250500117 oblique 117.
That doesn't help you, madam.
That is clear that I have no resemblance with that.
Madam, not reading is fine, but not listening also is a problem.
I'm reading.
So kindly appreciate. So now we were running short of time. I can't.
Any other, I'll satisfy.
Kindly appreciate. No, it's not a question of me getting satisfied. Judge doesn't have a discretion that much. You want to elevate kar do na, my lord kahi ki semti kichi nahi. Kindly look at 31. Read
31.
Read 31, page 31.
Yes, ma'am.
It is only to assist you.
Yes.
Read 31.
Yes,
An
31.
allegation petition.
Sorry, my lord.
Page 31 पढ़ंतु. An allegation petition. जो first paragraph पढ़िले वर्तमान.
Yes, my lord.
So now you place from page 30 where the ADM has dealt with that aspect.
Because ADM has recommended that I have.
Because our answer दियोंतुनी.
No,
Page 31.
Yes, ma'am.
No, I'll record. I'll pass order and I'll dismiss it. No problem.
No, my lord.
Because you are not inclined to argue the matter. No. Please, then kindly listen the question or you write it down. Where the ADM has dealt with the issue mentioned in page 31, section 3, 4 and 5 and that guideline of IGR.
The ADM has clearly given an inquiry recommended that the well, let's see the last line of third paragraph, that the society is eligible to be registered as state level society.
Correct. So that is not the issue I am asking you. Regarding the discussions made by the IGR in page 31, where the ADM has recommended, discussed.
That is just. The only objection sir, there is another association with same name does exist, my lord. But due to that, on the basis of that thing, that my application, I have received the order to change my name. But there is not.
Sri Lanka, this is not happening after the resumption of the procedure.
Only on
bench. So thereafter, I'll continue hearing because I have some other assignment now. There is a bench at 2 p.m. Thereafter, this bench will resume. So anyone have any difficulty? No adverse orders passed. It will be adjourned. Suppose there is delay in the resumption of this bench.
Lord, can we take it up?
Administrative law को वही पढ़ी
that is evidence act is a
administrative law रे को वही पढ़िले judicial review of administrative action.
I am sorry that I have no sort of.
Please read that. Please read that. When I joined bar here, I was kindly again my lord. At the case for you like boy विषय कथा चलছে my lord. I was told, the judges are referring to Wade and Forsyth. By that time, I had not read Wade and Forsyth. I have read administrative law, good author. So that is the problem. When you are arguing, you are inviting which read jurisdiction? Who read issue?
Read jurisdiction under article under read that is writ of mandamus.
Mandamus. So it requires judicial review of administrative action. So in that context, upon 31 the reason. 31 is a irrelevant consideration for 30. Administrative judicial review, so you have to argue a case, make an effort. ଆପଣ ହଠାତ୍ କହିଲେ ଯେ ADM recommend କରିଦେଲେ IGR ତାକୁ registration କରିଦେବା କଥା. That is your case, or I have understood you wrongly?
No,
is it not? अरे not then again ଆପଣ ସବୁ କୋର୍ଟ ରେ ସଲ୍ଭ କରନ୍ତୁ. ରୁଷିବା ଇଏ କରିବା ସବୁ କଥାରେ because you are not, I'm not distributing
There
things
is no
here.
question of.
So my problem is that I've been watching you, but a lot is expected from you. You are getting good number of cases. Administrative law, you should.
Yes.
Or you should have it fixed.
Your Lordship may grant me.
opposite.
17 sir mention କରୁଛନ୍ତି ଆଚ୍ଛା ହଁ ସାର୍ ଆପଣଙ୍କ ମ୍ୟାଟର ମେନସନ କରୁଥିଲେ ସେ କହୁଥିଲେ କେବେ ଆରେ ଠିକ ଡେଟ୍ ଆପଣ ସଜେଷ୍ଟ କରିନାହାନ୍ତି ସେ କହୁଛନ୍ତି ଯେ ଗୋଟେ ମିଷ୍ଟର ସରକାର କହୁଛନ୍ତି ଗୋଟେ ଫାଇଲ କରିବେ ଅବଜେକ୍ସନ you know institutional client that he said କରିଦିଅନ୍ତୁ ଗୋଟେ ଚେକ୍ आफ्टर वेकेशन चलिबो ठीक है ताले इनफॉरमेशन कर दियो
32 sorry
नहीं एक्चुअली I will resume but there may be delay so but
no but comment actually counter the last time we time नहीं आज भी counter देना that is
31 टा डेट करिया पड़ियो काले मिस्टर रॉय क्वेश्चन जे फ्री नाही ताका पागा ट्रांसफर है
no no सेटा तो मु एपीआर करछि से
और आपण
मु एपीआर कर सब उड़न किंतु से
सेकंड मैटर रे आपण एपीआर करछ
सब फर्स्ट केस रे से काउंटर टा दबा कर
ठीक है गोटे आपण केबे
रेगुलर कोर है नंबर है
34 31 ने काउंटर केबे दे परिबे 2023 मैटर
ओडियो को इसमें
वीक्स करियो करियो आपण दियंतु बट काइंडली दियंतु दियंतु
सर 32 टा गोटे
I have a pardon.
काउंटर बाय कर दियंतु 11 5 रही परिबो दियंतु आगे
यस हमका दे दो तब
copy serving copy thereof on the learned counsel for the petitioner second matter Mr. Das Mr. Roy jakko jaga re you are appearing
हम तो उतना फाइल लीजिए ना मुझे चेक करो नहीं
पेपरलेस जदी आपण
फाइल लेते हूं तो टाइम है
डेट के देबे 6 7 नहीं से रिजोइंडर दे
6 7 will come 6
नहीं 6 रे 8 7
we commencing 6 7
ओहो ठीक है
माने
आगे
रीओपनिंग रो 2 वीक पर
आगे
सर 32 टा इधर सर कंप्रोमाइज क्वेश्चन डबल नेक्स्ट वीक आसले सेटा हे जिवो
सर मिश्रा कोडे गले
मैं तो कहली
32 आपण डेट कर दियंतु के
आज्ञा सर डेट बोल सर कर
32 डेट करंतु आगे
आज्ञा
टी जल्दी 11 5 करंतु
आज्ञा
My lord, item number 12 and 13 may kindly take up today. If
नहीं नहीं बासी प्लीज मते आपण छाड़ देले माने आई विल
इलेवेंट को
I may be pardon my lord. My lord, I may be pardon.
अरे आपण एमपी मिस्टर भोई डोंट अपीयर in without robes I was sitting with justice Vishwanath Mathur you know how extreme view he takes never do that
My lord, sir,
pardon me lord आपण का फोन करी कहबे से मेंशन करिवे अकाउंट आपण मेंशन पे आछोंदी छाट पे
Pardon me, Lord. Item 11, my lord.
my lord, item 10, I need further preparation, my lord. Your
ठीक
lordship
अछि
allow-
आपण से ऑर्डर टा है ना do this आपण को गोटे ऑर्डर मते डिक्टेट करे पड़ो what I do in the court reflected in the order sheet
So,
No, your lordship may allow me short that I could.
वो आगे मना करछि केबे have you ever seen not granting एका 4 वर्ष परे काली एडजर्नमेंट दी 4 वर्ष परे डिफेक्ट सेतिरे कोन आपण ठीक टाइम दियो सर व्हाट आपण जोटा एडजर्नमेंट चाहउछंती बोथ पार्टीज एग्री सी डेट दे देबे
pardon me, Lord. Item 11. Your lordship directed to take instruction to the government.
I am resuming this bench after the division bench
They will take time. They have not filed
किछ
the.
असुविधा नै आपण सेफली यू कैन लीव I कह दी
item 11 my lord further
गोटे से मेंशन 11 कहू
two chapter
ड्यूक से रखू तो 11
to file counter
11 5 मिस्टर बेहरा
My lord.
I may be pardon to mention, my lord, item number 21. To remove the defect, my lord. 21, my lord.
You are Mr. R. Patra.
SR Patra.
ଆପଣ
SR Patra.
ଆଜ୍ଞା
ସମୀର ରଞ୍ଜନ ପାତ୍ର sir.
ଆପଣ ଆପଣଙ୍କ ନାଇଁ ବାକି ସବୁ ପାତ୍ର ଅଛନ୍ତି ଖାଲି ସମୀର ରଞ୍ଜନ ନାହାନ୍ତି
Pitambar Patra, ସମୀର ରଞ୍ଜନ SR Patra.
ନା ଭୁଲ ହେଇଗଲେ ଥିଲା
That mentioned as R Patra. SR Patra.
ଆପଣ ଏସ୍ଆର୍ ପାତ୍ର ଠିକ ଅଛି 2 weeks
My lord, item 24, my lord, I am appealing for
ଶୁଭୁନି
the,
ଆଉଥରେ କହିଲେ
my lord, item 24, my lord.
24
My lord, kindly next week, my lord. I am for the opposite.
ସାର୍ ଆପଣ ନୋଟିସ୍ ଆଡମିସନ କେତେଟା ଡିଚ୍ କରିହବ ଯୋଉଟା ଆପଣ ଚାହୁଁଛନ୍ତି ତାଙ୍କୁ କହିଲେ ତ ମୁଁ କହିଲି ସେ କରିଦେବେ ବଟ୍ ଡୋଣ୍ଟ ଇନସିଷ୍ଟ ଫର ଏ ପର୍ଟିକୁଲାର ଡେଟ୍ ସେଟା ଟିକେ ଅସୁବିଧା ହବ
My lord. Okay.
The Learned Counsel, the petitioner has addressed the matter. Actually, the petitioner is agreed by the order dated 30/12/2025. It is passed by the Inspector General Registration. There's Register of Societies. In rejecting the application of the petitioner, society, in the name they had suggested, the Learned Counsel for the petitioner has adjournment to address further. List in the week commencing, list for fresh admission in the week commencing. 11/5 2024.
Exactly not rejected, directed to modify the proposed name.
That I have marked.
That language is there.
Se kon hochi kale actually emane didi kochu na sei nata dakar.
That's it. That is
Interesting apan what I have seen.
Odia version of that.
I have some experience in this. There's some consultation actually. Many times two rival factions they fight it over the name.
इथे आजकाल तर म्हणजे इंग्लिश वर्षन रजिस्टर तार ओडिया वर्षन ताकू एମାନେ ଆପ୍ଲାଏ କରିବେ
Right. ସେଟା ଆପଣ ଆସିଲା ପୂର୍ବରୁ ସେଟା ଡିସ୍କସନ ଚାଲିଥିଲା ଯେ ultimate discretion and decision of the IGR with statutory authority whether court can interfere. That would be your argument actually. That I was telling her.
Can intervene in judicial law.
You can register your right.
Administrative law.
No judicial law.
ଆପଣଙ୍କର VG ରାମଚନ୍ଦ୍ର ସ୍କୁଲ ରିଟ୍ ରେମେଡିସ୍ ଆପଣଙ୍କର ଯୋଉ ଜଷ୍ଟିସ୍ ଅଡିଓଟା ବନ୍ଦ କରୁନି submits that counter has not been filed. The instructions has not been obtained as observed by the ordinary order. The Learned DGA seeks further accommodation. Stop. This in the week commencing 11/5/2024. Yes, madam.
Item 12.
May I please, madam?
Yes, please.
My lord, I am before this honorable court challenging the petition filed by the husband, which is rejected by honorable family court under order 6 rule 17 CPC. The amendment is carried out in a divorce proceeding, my lord, and many of the proceedings.
Stage of amendment, two stage amendment.
Pleadings not completed till yet. Only both the parties, they petition. I am for the petitioner, husband, and court below before the plaintiff. And I filed a petition for dissolution of marriage on the ground of adultery and cruelty. And opposite party filed WS, and subsequently I filed my examination in chief only. So, and after that, 110 order 1 rule 10 implemented as adultery party, and after implemented as a adultery as a party, and after that,
Adultery against wife.
my lord,
Okay. What they-
adultery and cruelty. And in another proceeding, 125 proceeding is filed by wife, and in that proceeding, the proceeding is going on, and from the evidence part of the wife is already closed, and from my turn, it continues since now. And during my cross-examination, OPW2, it is developed that a document which is filed by the husband before the Sahoo Samaj, which is in the year 2028, when any proceeding is not started between both the parties, that document is very much available to the Sahoo Samaj. And in that document, specifically pleaded everything that what is happening between both the parties, and the dispute is resolved by the committee. And that is a committee registration under Society Act. And that is a Sahoo Samaj committee. And they both the parties also belong to Sahoo Samaj. When the cross-examination part continue by the husband from the witness, and one of the witness OPW2 examined, then I came to know that a document is very much available with the committee, and in that document elaborately stated everything. So after knowing the facts, I made amendment in my order 13 petition along with the petition order 9, which is filed by wife against the husband in so cause. So both the petitions are totally denied, totally rejected by the family court on the ground. My lord, may I kindly say.
You are seeking for amendment.
My lord.
I mean, you are calling for that record or seeking amendment? That's the
Seeking amendment, because after calling for the record, that record was already executed.
So amendment regarding what?
Amendment in my pleadings.
The sequence. Can you appreciate the sequence?
My lord.
You file the plate.
My lord.
Then she filed the written statement.
My lord.
Now
I filed examination in chief also. After that, advocate change, and I implemented.
After your examination in chief,
My lord.
you have been cross-examined.
Again.
ତାପରେ ଆପଣଙ୍କର ସିଏ OPWT
नहीं एथिरे क्रॉस एग्जामिन हेनी सेटा 125 रा क्रॉस एग्जामिन चलथिला माने एथिरे कोन हिच ना जे हस्बैंड जो छंती से ओनली
आपण OPWT कहउछंती
आगे
OPW2
आगे
125 रे ना 13 रे
125 रे 125
आपण 13 रे से डॉक्यूमेंट आने ପାଇଁ चाहउछन
नहीं 13 रे हमें चाहउछु जे 125 रो प्रोसीडिंग रे जो डॉक्यूमेंट हमें कॉल फॉर करथलु एंड दैट आल्सो मार्क्ड एग्जिबिट विदाउट एनी ऑब्जेक्शन बाय द अपोजिट पार्टी बाय द पिटिशनर वाइफ इन दैट डॉक्यूमेंट व्हाट इज प्लीडेड हस्बैंड दैट इज elaborately discussion so that discussion
then suppose you want that document to be marked as exhibit
already exhibited
आपण तो मना करछु 13 रे
नहीं सेटा 13 रे त हमरो ऑलरेडी खाली प्लीडिंग्स भी कंप्लीट हेनी हमें एग्जामिनेशन इन चीफ ता खाली फाइल करूछु
आपण 3 रे जदी एक्जिबिट आपण प्रोड्यूस करे पे चाहउछु
एक्जिबिट प्रोड्यूस करे को चाहनु हमें अमेंडमेंट करिया को चाहउछु
लाभ कोन
कारण सेटा एडल्ट्री एंड क्रुएलिटी रा हमें जो ग्राउंड ता नेचु जोटा हमें वर्तमान चाहउछु
let us now assume that that document you must first think that you want pleadings to include the document or you want the document to be marked as exhibit.
That is not my my endeavor only to the pleadings, the amendment in pleadings. माने जोटा
adultery नहीं चंदी कहउछथि ना
adultery नहीं छी किंतु आउ सब्सिक्वेंट बहुत किछि होछि जोटा कि से डॉक्यूमेंट रो हमको हमें जानिलु
just kindly pause for a moment and think quietly. You are saying that you have filed 13-1 taking the plea of both. So in 125, another parallel proceeding, OPW2 has been examined. Suppose during the proceeding in 125, you find a document. That document you want as an exhibit in 13 or not?
No, that is already marked as exhibit in 125 proceeding.
13 रे सेटा चाहउछु ना चाहना
वर्तमान नहीं कारण हमर तो एविडेंस स्टार्ट हेनी हमें वर्तमान काई चाहिबो
जदी ताहले then you cross the bridge when it comes.
No, वर्तमान से डॉक्यूमेंट क्वेश्चन sir
because suppose suppose you have already taken the ground of adultery, then the issue will be framed.
But till yet not issue framed.
Correct. So why you are trying to cross the bridge before it has come? Because now suppose, because we are making a general discussion, I am not regarding this particular merit of the case.
My lord.
So if you want amendment, what amendment you will make? What is the schedule of amendment?
My lord, in my 13th petition, I only stated about a person Kranti. And in that amendment, which I want to carry out in my pleadings, stated about one Dr. Babu. And many of the things, how the wife taking cruelty against the, how the wife committed cruelty against the husband. That is elaborately discussion through amendment.
The problem is that is not a primary evidence. That I did not want to tell you actually.
Only I want to plead in my
so the problem.
Plant.
So if you try to, do you understand how you introduce a document, how to prove it?
My lord, whenever the
suppose somebody
if there is nothing in the pleadings.
So what is the difference between I suppose you produce an eyewitness to an occurrence. Now you produce a document written by a Samaj. You are saying there is an association. So how it will help you in proving, because you have already taken the ground of adultery.
Adultery.
So proving adultery, you can adduce as much evidence.
My lord. But beyond pleadings.
Because at least now, I mean, repeatedly I have asked you and you have told that stage has not come in 13.
My lord.
In 13 application, that stage has not yet reached where you have evidence, whether that particular document or any conversation or whatever. And obviously, you have to prove it. Whatever evidence you are adducing, the onus is on you.
My lord. But whenever the pleadings is not pleaded in my plant elaborately, then beyond pleadings, if I want to exhibit that document, the court is not bound to call for that same.
No.
And many facts which I want to plead it.
So you saw the schedule of the amendment where you have.
My lord. And most probably, my lord, he belongs to he know only my party know only Hindi language. He is from Chhattisgarh, and the previous advocate, what is stated or communication between both of them, that is not elaborately discussed by him in their previous plant. That's why all this difficulty arises when I engage in this case, my lord. And when the 125 proceeding going on between the parties, and I know the facts that elaborately discussion in that document, and that is also marked exhibit.
But you are saying about the document, that the problem is that, so that is how I'm trying to understand, because by including a reading regarding a document,
Madam, may kindly see that
why you are not waiting to mark that as exhibit?
Madam,
you see, unless now let us assume your pleading is amended. Correct. High Court directs that the pleading will be amended.
Madam.
Your purpose is to mark that as exhibit.
No, first, when the pleadings are completed, whatever I submit in the way of plant in my plant, which I pleaded, that much only taken into consideration.
No. If you are trying to prove cruelty, instances of cruelty, you will be
elaborately discussion in my
instance of adultery.
That is also pleaded. Beyond pleading that.
So the evidence will depend on what you have
pleadings.
Pleaded.
Yes.
So for adultery, whatever you have suggested, you may adduce evidence, you may adduce evidence, you may adduce documentary evidence, you may adduce photograph and prove the photographs. That's a different thing. But it's not necessary that you have to discuss that in your plaint itself. It's not necessary.
If the in my
kindly show the schedule.
So that amendment petition, my lord.
Annexure 433.
Annexure 4, page 33, my lord. Para A, in my plant also I.
Yes.
The petitioner family, only discussion by me, my lord. The petitioner's family earned their livelihood through cultivation and lived under difficult financial condition at the same time. At the time of my marriage, due to monetary problems, my elder brother wife delivered her child in her village hospital. Only elaborately discussion. All these facts are elaborately discussed by
that
me.
you should not include in plain. That you should include in your written amendment of. Affidavit amendment. Is there any provision? I am not very sure.
My lord, in my
Evidence in chief.
evidence in chief,
Evidence in chief. Have you filed?
already filed.
So now at this stage you want to because this is again not adultery. This is again cruelty.
Adultery and cruelty, both. My lord,
So A is cruelty. Then
page para C, my lord.
B is cruelty.
My lord. And para C is adultery. Regarding adultery, the specific allegation against the Dr. Babu, this is not pleaded in my plant. Only for Kranti Sahu, that was pleaded, my lord. Adultery and cruelty, both.
A lot of spelling mistakes. Lot of spelling mistakes. There's a difference between bowel and bow. Completely different. How the court has dealt with the court order?
My lord. Page 12, my lord. Annexure A, Annexure 1.
And the reason being that what you should be.
It released from the petition.
Because if you state complicated facts, it will be impossible to prove.
My lord,
You have
already.
to be very careful while trying to allege adultery and cruelty. Because if the facts get complicated,
My lord.
the standard of proof increases, the width and the breadth, the width and quantity of proof also increases. That creates a problem for you. You have to be very careful there.
But these facts are not foreign to her, my lord.
Because what you are, what is being written is very difficult. In fact, almost impossible to prove. Because you are saying that two persons are sitting together, you felt that they are very close. How you will prove in a court?
My lord, this is already discussed in my page 53, my lord. Sorry, page Annexure 6, page 43. This is the petition before by the petitioner before the Sahoo Samaj.
Sahoo Samaj document, you have to addition and prove it. It can be pleaded. Document can never be pleaded.
My lord.
So in fact, that was the discussion to tell you that what exactly you want. Whether you want a exhibit to be marked, whether because you are very clear in your statement, or because you are the conducting counsel.
My lord.
That stage has not come.
My lord.
Exhibit is yet to be marked. And even if you mark anything as exhibit, they may object.
Pleadings must be necessary.
No, pleadings may not be necessary, but you have to prove it.
My lord.
So your examination in chief and their cross-examination has to be there. And the author.
Examination in I filed, but period.
Author of the document you have to produce.
My lord. Husband is the author.
Suppose you are, suppose a document authored by Mr. Mahanti. Then you have to require Mr. Mahanti to prove the document.
My lord.
So those things you have to do.
This document is
not by amendment.
My lord. The author of this document is the husband.
That's a different thing. So
and he filed this document before that Samaj.
Correct. So,
and wife is also accepted the same in.
So if you want to file that document, you are saying that stage has not come.
My lord, but pleadings must be necessary to corporate all these things, my lord.
No, because you are yourself saying that you have pleaded on the wife towards the.
But against only Kranti Sahu, but Dr. Part and all the things which is happening.
So
that is not.
So why you are spoiling your own case? by saying statements against 2-3 persons will not help you, because then you require.
Well, that burden is on me to how to prove my case, my lord.
You must understand. Suppose you have to make X adulterer, Y adulterer.
My lord.
So now you have to call them to the witness box. They have to support you. You must understand. By
Adultery
alleging-
not supported direct. It's a tough task to.
So that is what I was telling you.
My lord.
That if you pitch it up very high, you create a situation where it becomes impossible to prove for you. When you are saying that you want to, implead as parties, so you have impleaded Kranti Sahu as party.
My lord, already
Then Bengali Babu, you want to implead as a party?
No, because Bengali Babu is not.
Then why you are weakening your case?
Because
always confine your case where to the extent you can prove it. Once you start, it is not the movie type.
My lord.
The trials in movies are completely different.
My lord, obviously.
Because you have to bring Bengali Babu. He has to support you in his chief. Other side will cross-examine. And cross-examination of a lawyer is very difficult to withstand for any lawyer is very difficult to withstand for any witness.
Man.
You must understand that. Even during discussion, certain questions a judge is asking, the lawyer is caught unwittingly telling the truth. How it is happening? So don't pitch it up that high. And if you want to adduce any evidence, let the stage come, because I have been asking you, you said very clearly, stage has not come. You should have framed. And
I only want
now by introducing your application before, it is your own document then. Now I have understood, because I am not getting.
But that is within the custody of Sahoo Samaj and not within my custody, my
You
lord.
have to call for that.
But whenever the pleading is not in my stand,
You must understand that you can suppose, unless now let us assume you get a document by RTI, copy of that document, some document, and you mark it as an exhibit. Does it amount to proving it?
my lord, whenever there is nothing any pleadings, if
You must
in my
understand.
stand,
No, please listen, then you can understand.
Sorry, my lord.
So now then, if you do not have that document with you, by pleading it, you are weakening your case. Now, if you want to have that document, then you call for that document. Let us see what is happening. But that stage has not come, as you are saying.
My lord.
Because initially I was thinking that after issues are framed, you have marked something as a
There is
document.
nothing, any issue framed by the Honorable Court till yet.
You have to wait for that.
My lord,
Because usual practice is that you will file your issues 5, 6, 7. They will file their issues and the court decides. In the sense, that is the usual practice.
But
written issues are filed.
My lord, whenever.
So what is the finding of the court on this?
My lord, page 14A, my lord. It reveals from the petition filed by the child that 14A, my lord. Page 14A. Only last portion. The findings of the court, my lord. Page 14A. It reveals from the petition filed that petitioner had knowledge about the affairs of his wife. Respondent number 1 with Bengali Babu. He, having knowledge about the affairs of his wife with Bengali Babu, and had not narrated the same in the original plan. Admittedly, petitioner through the proposed amendment has intended to insert 10 new paras and 20 sub-paras in original plan, and thereby attempt to create a new story. If the proposed amendment is allowed, it would change the nature and character of the suit, be that at it may, trial of the case already been commenced by filing the affidavit evidence 7/10/2024. And in their objection,
Madam Sarma, court is right.
Madam, may kindly see their objection.
Because now, suppose, in fact, that aspect the court did not ask you, because they are not discussing in general like I am discussing.
Madam,
you have already pleaded adultery, implemented him as a party.
My lord, whenever
So it is not the 13 does not define adultery. Wherever it is defined that multiple adulterous relationship.
My lord,
one adultery is enough.
my lord, whenever
how do you say order 6 rule 17 the nature and character of the suit is not
Malad, may kindly see just Malad 41 Malad page 41 again. Objection filed by the wife. Para 8. So जो कोई कि पर nature and character change and that is not needed previously, that is objection in that it is not less to mention here that the present respondent has filed the miscase against the present petitioner in this code via CMC number 109 of 2019 under section 125 CRPC, and in that case the present respondent has already closed her evidence and present petitioner has already examined himself as OPW1, and during the cross examination,
Madam Sharma, that court has not I mean this para
their
8,
objection,
kindly appreciate para 8 has the court taken note of para 8?
No, in their cross examination they said that this is subsequent development, and court said that why I'm not pleaded
para 8 in your application reply to order 6 rule 17, the London Judge Family Court has not been impressed with para 8. He has not referred to para 8.
He only said.
So why you are referring to para 8? Para 8 actually is besides the issue.
No, they said that opposite party said that this is subsequent development and this is not within my knowledge previously.
Again, that is not relevant, madam. This is not a conversation.
Malad.
When you are challenging a order, if the court has relied on para 8, then you have, you have a case to object to that.
Malad.
Court has not referred to para 8.
Court only refer, my lord.
Now only you have to confine, because we have discussed enough.
Order 6 rule 17, my lord, may kindly say.
Yes. So you have to show that it will not change nature and character of the suit.
My lord. Whenever there is a pleading, adultery and cruelty, my lord. I have no book, my lord.
No.
And order 6 rule 17 CPC is not strictly applicable on family court, my lord. And
kindly read. Then it becomes uncontrollable. If you do not
and its aim is for substantial justice, my lord.
No. You have to scrutinize, you have to satisfy the court that it will not, and in fact it completely changes the nature and character of the suit. Family court capta kodagala. Check. Dita. What did you? Madam Sarmango, what did you? What a court rely court the family court act co provision.
Again. But my order 6 rule 7 amendment of pleading 7.
Correct. So the nature and character upon your before the Lord trial court was that how you are changing the nature and character of the suit.
My lord, it is only elaborately discussion regarding cruelty, my lord. Amendment, my lord. Order 6 rule 17 may please, my lord.
Please.
Amendment of pleading. The court may at any stage of the proceeding allow either party to alter or amend his pleading in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial.
And the judge made, it has been interpreted by the Supreme Court and also High Court that it should not change nature and character of the suit.
My lord.
But 17 actually, in fact, you have disclosed yourself. You were aware for the commencement of trial.
No, my lord.
पढ़िबे टिके पढ़ंतु तापर आपण जो राउरकेला कथा कहउनांती कि ପିଟିସନ ରାଉରକେଲାର
ଆଜ୍ଞା
ଯୋଉ ଓକିଲ ଆପଣ କହୁଥିଲେ ଓଡିଆ ବୁଝିପାରୁନାହାନ୍ତି ହିନ୍ଦୀ କହୁଛନ୍ତି
ନାଇଁ ମୋର ଯୋଉ କ୍ଲାଏଣ୍ଟ
ସେ କୋଉଠିକାର ଲୋକ
ଛତିଶଗଡ଼
ଓକିଲ କୋଉଠିକାର
ଓକିଲ ପ୍ରଥମେ ସେ ଦେଇଥିଲେ ସେଇ ବରଗଡ଼ର
ସେପଟେ ସମସ୍ତେ ଓଡିଆ କହିପାରନ୍ତିନି ହିନ୍ଦୀ ବୁଝିପାରନ୍ତି ଆପଣ ଓଲଟାଟା କହୁଛନ୍ତି
ନାଇଁ ଛତିଶଗଡ଼ରେ ସେ ହିନ୍ଦୀ ବୁଝିପାରନ୍ତି
ଆପଣ ଯଦି ନୂଆପଡା ଯିବେ ବରଗଡ଼ ଯୋଉ ରାଉରକେଲା ସ୍ପେସିଆଲି ମୋର ଯେତେ ଜଣ ଓଡିଆ ସାଙ୍ଗ ସମସ୍ତେ ହିନ୍ଦୀ ହିଁ କହନ୍ତି
ବରଗଡ଼ରେ ନାଇଁ ସମସ୍ତେ
ନହେଲେ ସେ ଆପଣଙ୍କର ଯୋଉଟା ମାନେ
ନାଇଁ ବରଗଡ଼ରେ ତାଙ୍କର ହିନ୍ଦୀ ଅଲଗା ଏନ୍ତା କରବା मतलब उन लोग का अलग है थोड़ा
but the problem is that ଆପଣ ତ ନିଜେ ଲେଖିଲେ ଯେ the incidents happening with Bengali Babu is much before the trial comments you have written
no my lord मैं कहने से पेज annexure 4 पेज 3
अरे पैराग्राफ पढ़िबे ना आपण शेड्यूल ऑफ अमेंडमेंट टा पढंतु
नहीं एटा पूर्वरु मु जोटा देछि that till yet pleadings not completed in the meanwhile petitioner changed his advocate who present this case previously in the meanwhile when going through the files and examine the pleadings it come to my knowledge that all the facts which communicated by him your husband in Hindi
not a ground na is not a ground आपण अच्छा मु बर्तन बुझिली आपण जोटा कहउछन इट इज नुआंस्ड जे आपण उकिल को देथिले उकिल बुझी पारलेनी
नहीं माने से जहा फैक्ट कहिथिले ताले से प्रॉपर्ली ताको एलाबोरेट डिस्कशन करी की करि नांती
आउ करियो एटी किछि प्रोविजन नाही से पिछरे बिकॉज़ आपण जोटा इंसिडेंट नरेट करूछंती आपण का अमेंडमेंट प्लीडिंग्स रे जस्ट काइंडली रीड द प्रोविजन स्लोली ऑर्डर 6 रूल 17 स्लोली पढंतु provided that no application for amendment
shall be allowed after the trial has commenced but trial has not commenced
trial has commenced
no not commenced
court has said that the High Court cannot say that it has not commenced. आपणकर ट्रायल कमेंट्स नेले एग्जामिनेशन चीफ केमती हला
एग्जामिनेशन चीफ ओनली खाली फाइल छि ट्रायल रे एग्जामिनेशन चीफ खाली फाइल लबोनी से डॉक रे आसी जेते बेले विटनेस पई ओथ नेबे ताले एग्जाम
सेटा ट्रायल नो
that is the trial my lord
no
when the witness is come in the witness box and taking oath
सेटा एग्जामिनेशन ऑफ विटनेस कहउछंती
नहीं सेटा एग्जामिनेशन चीफ को सतबेले हां एग्जामिनेशन से टाइम रो स्टार्ट होची
ना इट इज एग्जामिनेशन नो ट्रायल कोनकर ट्रायल हे की जेते बेले आपण फाइल करि देले द ट्रायल हैज स्टार्टेड
but it should not
second point is the problem
after that 110 petition filed by me and consolidated plan
आपण धरु जेतली भी पिटिशन फाइल करले भी
again
once it has started it cannot be said that it has not started
नहीं तापर जेतबेले मु 110 petition ता दिल्ली सेटा अलाउ हैला तापर से डब्ल्यूएस देइचंती तापर
कोन रहिला ट्रायल स्टार्ट हवा
तले प्लीडिंग्स टोटली कंप्लीट हेनी सर
कंप्लीट आपण तो नीचे कहउछन मु देई सलेनी
नहीं 110 क्रांति साहू का में पार्टी बने
first of all you do not have a case regarding a trial has started but obviously substantial justice जोड आपण कहउछंती द प्रोवाइडर सेकंड पार्ट ता देखंतु आपण जेटा अमेंडमेंट कहउछंती
अगेन
amendment you are entirely narrating the event which was prior to the case that is the problem
मतलब all these pleadings are not pleaded and not elaborately discussion my lord
सेटा आपण even have you marked that even आपण limitation act suit रे limitation is absolute bar
सेटा नहीं सेतबे लिमिटेशन इंस्टीट्यूशन ऑफ सूट में
once you miss that opportunity of pleading that cannot be done
मतलब for institution of suit or whenever I want to document which is within my knowledge but it is not pleaded that is affect my lord किंतु एटा तो मो नॉलेज रे परे आसिला
so why should you damage your own case
my lord
आपण when आपण पाखरे जेति की मटेरियल अछि
again
you have pleaded the adulterous affairs with Kranti Sahu so now you prove that now you unwittingly now the problem would be you will be asked these questions also most likely your client will be asked these questions
but cruelty is not elaborately discussed my lord
now, if I have understood you correctly now that you are saying you are attributing it to the lawyer was not understanding Hindi the client told Hindi so he did not place it on record in the plaint
and
that is the case
and
that is very that is a impossible ground
my lord and that document is also not available with me during the cross examination of in
document whether you should plead that's
but then story कहले
आपण से it can be retold
madam me kindly then fix another date I मतलब regarding when the trial commence and
Commencement of
filing of only examination in chief is not taking that the trial is commenced, my lord. My lord, may kindly take up this matter on Monday. On 617 ରେ ଆହୁରି ଅଛି judgment ମୁଁ ସେଟା ଆଣିକି ନହେଲେ
6
the court refers to the point when the court starts examining evidence, obtain different date and the machine check is good.
You see, I have not much practice, but have some impression. The day you filed your, because now after amendment of CPC, the petitioner is not allowed to go without affidavit. Both examination in chief in form of affidavit. At times cross also, it is WS your opposite party's evidence is also by affidavit. So the trial has commenced. The day you filed, then read order 617 again.
But my lord, this is not stringent provision applicable on family court, my lord. In that point,
family court re apanakar dekhundu koti achi seta. Apon seta case
family court has their own process, my lord.
For shooting of the hip junction is jo. If you see American movies, they will start shooting. They will not point like this. Justice Sinha used to always say that mother wit and shooting of the hip will not help. You have to hit the point. Who is applicable? Habani so nine actually.
Man, no, sombar din seta rakho jo mo satisfied.
Ita apon alga katha kouchandi. Apanakar first contention that the trial had not started is not correct. Second point is actually completely you have yourself created a situation where you have narrated events of Bengali Babu which was much prior to the trial. Much filing of your suit under 13 alleging adultery. This Bengali Babu incident is prior to the 13 filing of 13 also.
Madam.
So how can you say that you became kindly read that again. The language used is
17. Order 17.
Proviso. Order 6, Rule 17, Proviso.
Madam. Provided that no application for amendment shall be allowed after the trial has commenced, unless the court come to conclusion that in spite of due diligence. So what is due diligence?
So now the problem is that you have on oath you have stated the incident with Bengali Babu, which is prior to.
Because here is the word.
Whose knowledge is attributed? In your amendment plaint, you are attributing the knowledge to yourself.
When the cross-examination is going on.
Cross-examination, you are saying that document is furnished by you before the
no, when cross-examination is going on, during that time, my witness told that this document is very much available with us.
Now you have forgotten perhaps. To my question, you are saying that that document is authored by you.
Madam.
So then how can you say that X is saying or Y is saying?
But that is not
so that document authored by you is happening prior to the filing of the suit also even.
But that document is not within my custody. That is within the custody of.
So that you call for that document. For that,
Madam.
How the court will allow amendment?
That's why the amendment. That's why the pleadings which is mentioned in that petition, I want to elaborate a discussion in my plaint, my lord.
That cannot be.
My lord, here is the word
Order
due diligence.
17 is a bar, clear bar actually.
My lord, here is the word due diligence.
Exactly. So how do you say that which you have authored? The incident is narrated by you. That despite the exercise of due diligence, you did not tell in the plaint. For that only you are saying you told the lawyer has not written it.
Then, my lord, I satisfy regarding this due diligence, whether that is due diligence has been.
You are not understanding the point even. You are struggling there. You look at your proposed amendment, schedule of amendment. You have yourself said that you know these things. In paragraph A, B, C up to E up to J, whatever you have averred was within your knowledge, that is your own statement.
May kindly take up this matter on Monday, my lord.
And kindly just look at your application, where you have stated, have you mentioned that line, that the above statement could not have been disclosed despite exercise of due diligence, because you cannot do that.
The facts and circumstances are differ without disclose or discuss elaborately, it losing value and party will unable to get proper justice.
Why you have not used that? No, that is not the language of CPC.
And para 3 also, the proposed amendment not foreign to opposite party, all these facts are within their knowledge.
Sorry?
The proposed amendment, para 3, in my proposed amendment, annexure 4, this proposed amendment not foreign to opposite party, all these facts are within their knowledge.
Pronunciation, I have to read it myself.
This proposed amendment.
That is not a ground to allow amendment. Order 6 rule 17 upon the ulta lekhi. You have written the amendment not foreign to opposite party set no. All these facts are within their knowledge. The amendment is sought for by the petitioner, who is plained. Now you have to say, despite exercise of due diligence, you could not have produced avert that before in the plaint. That you have not written, and purposefully, because the entire narrative is within your knowledge only.
No, that's why.
Whatever you have said, and regarding that document, you can always call for that document. It is for you. Whether you will be able to prove that, that's a different thing. They will object or accept. Let us assume your pleadings are not allowed or allowed, but document can always be called for.
Without pleadings, how that can be?
Because the problem is that whatever you have pleaded regarding the extramarital affair of the wife is your knowledge you are attributing.
But that is only.
I saw them sitting together. I saw them eating chicken curry. My wife had prepared. Anything inconsistent, but I mean, it is common knowledge, procedural law is CPC, and CPC takes care of everything.
The provision of
otherwise, you see, when you are filing Order 6 Rule 17, Order 1 Rule 10, how do you say that CPC is not applicable? You are
CPC is applicable, but
you stand by CPC, follow CPC also.
But in that is strictly not applicable, I mean to say.
No. Order 6 Rule 17 cannot be applied in piecemeal. It has to be in full force.
Madam, kindly fix another.
Unless the court comes to the conclusion, it's very difficult. It's assigned to the court. I mean, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. Correct. Now suppose Order 6 Rule 17. Now just, I mean, leave your, brief dekhantuni, acta dekhantu, statute. The court has to come to conclusion
that in spite
of due diligence, the party could not have raised the matter. This is a difficult proposition. Because no court can come to conclusion that when you, in an amendment reading, you are saying about the relationship attributing to your personal knowledge, to a conclusion.
Provided that no application of the amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of
Correct.
trial.
So suppose now let us assume I get impressed by, I mean, whatever I allow this, rightly or wrongly, I allow this application of amendment. Then what would be my order? That despite exercise of due diligence, you could not have knowledge of these things, whatever you are saying, could not have raised. But whatever you are raising now is within the exclusive knowledge, within your knowledge.
And if my lord may kindly permit to
So
file a supportive.
actually, the problem is that don't try to repair your case. That will create problem for you. Because suppose now this affidavit is confronted to you, your client, you have already filed in the court, order 6 rule 17. Court may not allow it. That's a different thing. I'm just telling you a hypothetical. Suppose the family court, before the family court in cross examination, this is confronted to your client. Then he will be demoralized to answer properly. You must understand. By repairing times you create problems.
My lord, that is not repairing. This is happening in his life, my lord.
Because you are adding more grounds to prove mental cruelty.
My lord, the facts which is stated by him, that is only.
I mean, once he missed not to state that, and now in order 6 rule 17, when there is express FAR, the court has to come to a conclusion that despite exercise of due diligence, these facts could not have been maintained in the place. That is the problem. That stares at you. I mean, that stares at the court also. You file an affidavit narrating everything which is within your exclusive knowledge. So how the court will say that?
But that is
despite due diligence, you could not have.
But that is only filing.
Because the principle is that the adjudication should attain finality, not never open ended. Just imagine now since so your proposed amendment, it is very clear that you are disclosing certain things which you could have done because it is all your personal knowledge.
My lord, again I examine all the facts and place before the court. My lord,
Lakshmi Sharma for the petitioner. The petitioner is the plaintiff. Petitioner husband is the plaintiff. MAT case number 14 of 2024 before the learned judge family court Bargad. He filed application under section 13 of the Hindu Marriage Act. The suit being presented. Date ta koi pariyo? Date ta dekha jani.
Suit ta mane kodino present ide.
In the year 2024, for grant of decree of divorce and dissolution of marriage solemnized between the parties of 25.04 of 2007. The grounds seeking the divorce is under section 13 of the Hindu Marriage Act, alleging cruelty, adultery on part of the wife towards the husband. Para. After filing of the application, the alleged adulterer, spelling check, has been implemented as a party by filing application under Order 1, Rule 10. Thereafter, application under Order 6 Rule 17 CPC was filed on 9/2/2026.
19/2/26
Filed on 9/2 ଲେଖା ହେଇଛି
ଆଜ୍ଞା 1/19 ଆଜ୍ଞା
9/2 ନା 19/2
9/2/26
କଣ ଲେଖିଲି on ନ କଲେ କିନ୍ତୁ application dated କରିଦିଅ sure not application dated 9/2/2026 was filed seeking amendment of pleadings as per the schedule appended to the application. The learned Just Family Court has dealt at length the contentions of the parties in the Order 6 Rule 17 application. So, this is actually it is very difficult. It was stated that while going through the pleadings, it came to her knowledge that facts communicated by his client in Hindi to his predecessor advocate has not been properly for the pleadings. You should not have stated.
whatever the client told me that is only stated by me.
Then something is suppose something is against you.
Madam.
Then they ask your client. Then what would be his answer?
But as per the officer of the court, whenever the honorable court asked, then truth must become.
No. Don't make a general statement.
Madam.
When you are finding fault, perhaps you are not understood the question. You are saying that your plate is faulty.
My plaint is faulty.
Yes.
No, not elaborately discussed, not faulty.
Whatever.
Elaborately not discussed.
You are yourself saying by filing an application that my plaint filed before this court is not correct because whatever.
But not properly stated. Elaborately discussion is not.
Should not. Because you should always use measured language. It may be a boomerang for you. Because the best part in your plaint will be confronted if you make this statement. And you have made it on oath.
Madam.
Suppose, is it that your entire plaint is bad?
No.
Correct. So that is the reason. So you should use the language which will not impact you. You have to be careful. Application and dismiss the same. The operative portion, also including the reasonings of the learned judge family court, is reproduced here. Peruse the petition filed under Order 6 Rule 17, the page 14 capital A range. So, 14 capital B version CPC is rejected sans merit version. Facts are that
is disputed by me. That's why I am before this honorable court, my lord.
Listen to the order. Don't predicate the order. You are not following.
Sir.
The entire thing becomes so farcical. The undisputed facts are that the petitioner has filed his evidence in shape of affidavit on 7/10/2024. Then his prayer by filing application under Order 1 Rule 10 CPC was allowed by the learned judge family court. Learned family court by order dated 27/1/2026. One Sri Kranti Sahoo was added as R2, respondent 2. And the application under Order 6 Rule 17 CPC for specific amendment was filed on 9/2/2026. So you have completely damaged by filing this amendment application. In fact, what I'm telling you, now the court has taken note of that. I have not gone through that. The court says, you just listen, kindly read page 14.
Madam. Para second. Second
Yes.
para.
14 the second para.
Per contra, learned counsel for the respondent number 1 whimsically contended that petitioner husband has filed his evidence in shape of affidavit on 7/10/2024. Thereafter, he made prayer to add Kranti Sahoo as a party under Order 1 Rule 10 CPC, and the same was allowed by the order dated 27/1/26, and accordingly, Kranti Sahoo was added as respondent number 2. Thereafter, through petition dated 9/2/2026, made prayer under Order 6 Rule 17 CPC for a specific amendment. He, the petitioner, husband, under Order 6 Rule 17 CPC, has developed new concocted stories stating therein that respondent number 1, the wife had extramarital affairs with one Bengali Babu.
So now this thing you have created. You should have been very careful before filing this, making statement which are well within your knowledge. How this submission is in response to your Order 6 Rule 17 petition. They have in fact grabbed that opportunity. Anyway.
The fact was not narrated in original plant also, they stated that.
Which you could not have narrated despite exercise of due diligence. Whatever you are narrating in your Order 6 Rule 17 application is completely within your knowledge, and it is prior to the filing of the suit. That's the problem.
My lord, elaborately, again, I satisfy all the query
Nothing.
to this
That
court.
is nothing. It is taken.
They kindly fixed another date on Monday.
Let us not waste time today. I have spent 1 hour on this. I have
My lord, if this amendment is not allowed, totally prejudice to the husband, my lord.
Whatever.
My lord,
See that the case is not.
my lord, and the one transfer
Madam
petition is
Sharma,
also filed by me.
Sharma, please appreciate this. The law is not looking at a particular person winning, but the law must prevail.
My lord,
Whether prejudice, you see, then the cases have to be filed for winning only. Why the persons are losing cases?
my lord, then my lord may kindly fix to one date only.
Yes, it will be fixed, but what time by not recording the discussion?
That is not a wasting of time. Due diligence. Why?
What you want? I will not record my discussion.
My lord.
No, you should not. You are going too far. You are going too far. You must understand it is recorded. If I send it to the Bar Council, what would happen?
My lord, may kindly fix.
After arguing 1 hour, you are telling the court that your submission will not be recorded.
No, my lord. My lord, this is upon the court, my lord.
No, I told you that you will get time, but I can't waste time by like this. That after discussing 1 hour, I will not dictate order. You take your seat.
My lord.
Or like me. What did I quote? The prayer for amendment of the pleadings invoking Order 6 Rule 17 has been rejected on the ground that the trial has commenced when the petitioner husband had examination in chief in shape of affidavit on 7/10/2024. It has been further observed by the Learned Judge Family Court that the petition filed under Order 6 Rule 17 shows the petitioner had knowledge about the affair of his wife, respondent number 1 in the matrimonial case, with quote, Bengali Babu. It has been further noted by the learned judge that the petitioner husband, having knowledge about the affairs of his wife with Bengali Babu, had not narrated the same in the original plate. Order 6 Rule 17 of the Civil Procedure Code, which has been sought to be relied upon by the plaintiff, seeking amendment, has definite bearing on the case and is reproduced herein. Order 6 Rule 17. This court does not find any error in the findings of the learned trial court, learned judge family court. So, it has to be further observed that Order 6 Rule 17 proviso would have significant bearing on the case at hand. So, the proviso puts the responsibility on the trial court to come to conclusion that, in spite of due diligence, the party could not have raised the matter before the commencement of trial. Stop. Perusal of the schedule of amendment in the application, which has been annexed to the petition, marked as Annexure 4, at paragraphs A, TO2, A to J, indicate the petitioner has gone at length to narrate his personal knowledge as he has narrated his version of instances of cruelty. Those are the happenings which are and were within his knowledge prior to filing of the MAT case. The incidents which he also has exclusive knowledge, as has been narrated. Exclusive, no, he has knowledge which have been narrated, alleging adulterous conduct of his wife were well within his knowledge. Before filing of the plaint, before filing his evidence in affidavit, and also filing the Order 1, Rule 10 application in pleading. The alleged adulterer, a party. It is further submitted by the, as an alternative submission, is submitted by the learned counsel for the petitioner that the Code of Civil Procedure would not be applicable in
Strictly applicable.
would
Not
not be
strictly.
would not be applicable strictly to process under the Family Courts Act. In this regard, the provision, the section 20 of the Family Courts Act would have a bearing and is reproduced herein. The submission has to be rejected in as much as the procedural law guiding the for the family court is governed by the CPC. The definition clause 2E includes the CPC. Reproduce कर देंगे. Have you checked E?
No, madam.
2E देखो.
Madam, put a date दे दो.
All other words, expressions used but not defined in this act and defined in the procedure shall have the meanings respectively assigned to them in that code.
Madam, book is
ଆପଣ କାଇଁ ବହି ନେଇ ଆସୁଛନ୍ତି ମ୍ୟାଡାମ ଯୋଉ ବହି ଦେଇଥିଲେ ଦିଅ CPC କଣ ଫ୍ୟାମିଲି କୋଡ୍ ଦେଇନାହାନ୍ତି 2E ଟାକୁ କୋଟ୍ କରିଦେବେ ହେଲା. It has further to be noted that Order 6 Rule 17, Order 1 Rule 10 have been relied upon by the petitioner himself to seek relief from the court. And after he has failed in his endeavor, as the applications have been rejected, he cannot turn around and say that Order 6 Rule 17 would not be applicable. In any event, assuming that the amendment can be allowed, it has to be under the provisions of Order 6 Rule 17. अब आपनकर कोन पॉइंट रहला
मानट गोटे डेट रखा जाऊ
सेटा तो
तेइस ऊपर मु सैटिस्फाई करबी
अछि
नहीं ए सब पॉइंट पर मु सैटिस्फाई करबी जहाटा आगे करी
सैटिस्फाई करियर
मानट मे काइंडली फिक्स्ड अनदर डेट मानट मे काइंडली
ऑब्वियसली और केबे चाहछन
सोमवार
at this stage the learned counsel for the petitioner has 6 and has adjournment as she hopes that she can improve upon the case heard today for 1 hour and 10 minutes or 1 hour 20
मानट
at least in the week commencing आपण भुवनेश्वर आछन ना
नहीं कटक रो
तो you suggest a date matter shall be listed for fresh admission
मंडे और ट्यूसडे
नहीं सेटा से कोन डॉक्यूमेंट मु जाननी आज के तारीख 17 इन द वीक कमेंसिंग कोडिया रे को दिन आपण आसी
मानट जो दिन फिक्स्ड करिवे
नहीं नहीं अरे जो दिन तो से कंप्यूटर न बनी ना कंप्यूटर रे जो दिन टाइप करे कोन होची
21st
कोईसी मंगलवार न्यूतन ना हबल
नले बुधवार
भूलभाल केस मंगलवार दिन नेबे
नले मंगल बुधवार नले न्यूतन 22nd
it's a joke you should be fair don't I mean it's a worth experiencing आपनो पय भी मो पय भी that whatever time we have spent we have discussed some law that is important
but malot already
आपनो का प्रॉब्लम हो जे आपनो गोटे self inflicting injury mode रे अछंती. In fact, I was not expecting this. In fact, that is the point. That was the sole ground your other side has argued there. आपण जेतेबेले don't inflict आपण जेतेबेले जेति खराब हेछि डैमेज हे जायछि प्लेन का ताको आपण जदि कोर्ट रे एफिडेविट फाइल करियो म प्लेन भूल हे गला यू नेवर नो से को माने स्मार्ट लॉयर के थिबे लाइक मिसेस पटेल हेला कन्फ्रंट कर देबे
ହଁ
ଆପଣ
ଯଦି
ନିଜେ
admission ଯଦି ଅଛି
କହୁଛନ୍ତି
ତାର
ଆପଣଙ୍କ
ସେଟା
credit
confront
ଖରାପ ହେଇଛି ବୋଲି, so you never know, so that you have to be careful.
ଆଜ୍ଞା
13 ମ୍ୟାଡାମ 13ଟା କଣ ପିଟିସନ
13ଟା ବି ମାନେ ସେକ୍ସନ 9
17
ଅର୍ଡର 617 ସେଟା ବି ସେଇ ଦିନ ରଖାଯିବ
ଆଉ ଗୋଟେ
ଆଜ୍ଞା ସେକ୍ସନ 9 ଯୋଉଟା ୱାଇଫ ଫାଇଲ କରିଥିଲେ ସେଥିରେ ମୁଁ ଆମେଣ୍ଡମେଣ୍ଟ ଦେଇଥିଲି ସୋକୋଜ ରେ
amendment of
May so
written
cause.
statement
in my written statement
WPC 10925 of 2026
10925 10928 of 26
sorry 1092 the connected WPC 10925 of 2026 been posted to 21 has been hard extension posted to 21 4 2026 according to the matters that they listed along with the said petition on 21 4 2026 rest of the matters upon distribute kari paribe kebe karibe 4-5 week re so budaka all the matters which are not adjourned the court master is saying that he will distribute in the week commencing 4-5
item 29 let's file that will be order item
29 ne counter hini
counter 22 मसीहार केस
29 Mr. Prabhu or Mr. Prem
पुणी आसो पुणी 22 मसीहार नोटिस
We'll ensure that.
but it's a Prem when your presence why the family court matters are getting so acrimonious in both of your presence when Prabhu is there Prem is there still that is not happening so much of acrimony between husband and wife at least the case should lead for amicable settlement yes
Well, I'll ensure that it will be filed by the next day.
11 एक 23 रे order
22 कहले
29 years
29 sorry
11 एक 23 रे order कर
29 टा डेट कर दियो
we can't
after vacation
ना काउंटर पे ଗୋଟେ order हो देले
नहीं out of turn करंतु
ଗୋଟେ counter
that we should respect other lawyers also once we have stopped taking up the list man it should not डेट करंतु सेति की तो कहि जाउची कंप्यूटर रे
असले
6-7 week
6-7 आउट हो जाए
कोनकर 6-7 होची just second week after review
last week
रखिबे 18-5
Counter.
22-23 मसीहार हलाने
तो लिस्ट कर नथिले आ कोन
लिस्ट हेई न नथला बहु कष्ट लिस्ट करछि
तो ठीक अछि सर बहु कष्ट नहीं बहु कष्ट लिस्ट हेछि सर 18-5 week रखि था this week 24
Lordship, item number 38, can it be alert?
Madam,
Item
I'm
number
just going
38.
page wise. I'll go page wise. That will be convenient. Upon कोड एंगल serial 13 ठीक अछि items 14 to 16 item 18 and 20 अपन जोटा डिक्टेशन पे अछि ताकू लास्ट डेट एतो डाकू item 23 24 25 24 yes
what a date
सेटा कि ओटे मेंशन करथिले adjournment पे ओटे
माइलो
मेंशन करथिले agree for a date after na before vacation
will be convenient
6-7 कर दियंतु ता
कोई कौन दे 6
great
ऑफलाइन
interim order
जदि stay थिबो I am not touching it no interim order is touched
ऑफलाइन
then 27 28 29 30 30 yes 29 ता आपण डेट करते काउंटर ता अंडरस्टैंडिंग इज दैट ही विल फाइल काउंटर
मतलब 30 भी अर्जेंट आफ्टर वैकेशन
आगे
अर्जेंट आफ्टर वैकेशन 30
30 टा
माइलो
ठीक है 30 टा को ओटे डेट कर दियंतु
वो कौन से 6-7
6-7 वीक page item 35. Madam Das, 38.
Yes, my
Vacate
lord.
केबे चाहुचंती?
My lord, prior to vacation, in the first week of
before
May,
vacation କରିପାରିବେ? We commencing 18/5 कहउचंती.
my lord, before that week,
18/5 तो 11/5 रे से
it will be difficult for me. my lord.
11/5 रे 90 पहुंचे सालेणी से.
4-5 week
11/5 रे आसु. 4-5 is showing 92 थिला आजी. So ता देर जा आड हेतिबो. से आज किछि ऐड करछन 4-5. It has reached 100.
My lord.
11/5 week रे देखंतु.
आज्ञा से week रे रखते.
39 to 42.
Grateful, madam.
Yes, madam.
Item 42.
42.
In the month of May.
Before vacation जाउछन.
Before
हो ठीक अछि. 42 टेट करो.
ओके 18/5.
18/5 week. 40 टा मिस्टर विश्वाल कोन आफ्टर वेकेशन ना
ସେତେବେଳକୁ ଆଉ ନଥିବ ସେ ଲୋକ
ତାହେଲେ ରଖନ୍ତୁ ଏତେ କାଉଣ୍ଟର ଅଛି ଏଥିରେ
କାଉଣ୍ଟର ଅଛି ସବୁ ଅଛି ଖାଲି
40 ଟା ରଖନ୍ତୁ ଡେଟ୍ କର
ହିୟରିଂ ହେଇଯିବ
11/5.
we commencing 11/5
39 also
39 also
after vacation.
39 ଦେଖନ୍ତୁ
18/5.
we commencing 18/5
this time ଗୋଟେ ମିଷ୍ଟର ସାମଲ also old method that would be
ଆପଣ ବର୍ତ୍ତମାନ ଯୋଉଟାକ ଅର୍ଡର ପାଇଁ ରହିଲା ଡାକନ୍ତୁ
17.
the matter being in the list during course of the day it was mentioned at the beginning of the day's proceeding the appearance देखिए Mr. Sasibhushan Jena for the petitioner Mr. Nilamadava Sarkar अच्छा इतने ऑर्डर कौन देखिया जाता है ଏଥିରେ ଆପଣ ତ ସେ ଅବଜେକ୍ସନ ଦେବେ କହିଲେ
ସେଇ
ଠିକ ଅଛି ଆପଣ ଆଚ୍ଛା ଠିକ ଅଛି ଉତ୍ତର ଲେଖିନ୍ତୁ ହେଲା ସସିଭୂଷଣ ଜେନା ମିଷ୍ଟର ନୀଳମାଧବ ସରକାର the learned counsel for the opposite party submits that he may be granted accommodated further to file objection to the delay condonation application. Stop. Accordingly, the matter shall be listed on 18/5/2026. The objection on behalf of the opposite party shall be filed upon serving copy thereof on the learned counsel for the petitioner.
Item 21.
Mr. S.R. Patra for the petitioner, opposite party blank. The matter could not reach during the day's proceeding due to paucity of time. Mr. Patra, Mr. S.R. Patra submits that his name has been wrongly mentioned as R. Patra, which shall be corrected by the which shall be corrected as S.R. Patra in the first list. Stop. Then para. 2 weeks time is sought for by the learned counsel for the petitioner for removal of the defects. Accordingly, 2 weeks further time is granted for removal of the defects as counted by SR. The date करचंती की?
No, 2 weeks.
Liberty to mention they do. Next.
31.
31, Mr. Sethi, you are there in 31.
Yes, your lordship. Yes, your lordship.
Sir, Samir Kumar Das for the petitioner. First matter, the matter. First matter. WPC 43004204. 31, Mr.
Yes.
Samir Kumar Das for the petitioner. Suman Sethi for the additional standing counsel for the opposite party. The matter being in the list could not reach during the day's proceeding. Stop. It is mentioned by the learned counsel for the petitioner, stating that the counter has not been filed. Accordingly, it is directed counter affidavit on behalf of the opposite parties be filed by 11/5/2026. Serving copy thereof on the learned counsel for the petitioner. Petitioner shall have liberty to file rejoinder in response thereto. Stop. The matter shall be listed in the week commencing 6/7/2026. তারপর লিখবে WPC 3631020220. Second matter. The matter is listed along with WPC 430004 of 2023. It is submitted by Mr. Swapnil Roy, learned counsel, that the petitioner has obtained change and he given his consent for the consent to the petitioner to engage any other counsel. So, Mr. Samir Kumar Das, learned counsel, submits that he has instructions to appear and has filed a Wakalatnama. Stop. Name of Mr. S. Roy shall be deleted from the case brief as well as the cause list appearing for the petitioner. Name of Mr. Tapar likhve upon filing of Wakalatnama, the same has been to the brief, scanned copy be updated. Name of Mr. Samir Kumar Das, learned counsel, and learned associates shall be indicated in the cause list as well as the case brief appearing for the petitioner. Second matter re counter achi Mr. Ajit Sood. Yes, Mr. Sahoo, item 28.
Whether that matter has been adjourned or
No, I don't think authority ki mention kartile. No, it has been it will go after vacation. You want or
sir.
You want a date?
Yes.
What is the date karo?
We commencing 6/7.
We commencing 6/7.
Obliged, sir. Stay may kindly be extended.
Stay remains untouched.
Obliged.
Serially, since there was break bench and other things, serially I could not cover the list. So I'm just going page wise.
So we commencing 6th July.
ଆପଣଙ୍କର reopening week ର per week.
Sir.
Second week after reopening.
Obliged, sir.
Thank you.